Oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-5172. Monte Rose Jr. et al. Versus Robert F. Kennedy Jr., Secretary, United States Department of Health and Human Services in his official capacity et al. Indiana Family and Social Services Administration appellant. Mr. Bartos for the appellant, Mr. Boldy for appellees Robert F. Kennedy Jr. et al. Mr. Redd for appellees Monte Rose Jr. et al.
Good morning.
May it please the court. The Healthy Indiana Plan, or HIP, expanded Medicaid to cover hundreds of thousands of users while allowing all beneficiaries who make small, predictable contributions to power accounts to access benefits that traditional Medicaid does not provide, like vision and dental, and to avoid making unpredictable time of service copayments that would apply under traditional Medicaid. The Secretary reasonably determined that HIP would likely advance Medicaid's goals of allowing Indiana to continue providing greater coverage than would otherwise exist. In vacating the waiver, the district court made three principal errors. First, it moved the statutory baseline for assessing projects, requiring the Secretary to explain why HIP was better than hypothetical alternatives rather than just why it would likely advance the statute's objectives. Second, it shifted its focus from the project as a whole to individual elements of that project. And third, it imposed a remedy that not only fails to redress the injuries alleged, but whose disruptive effects are out of proportion to the alleged error. But before I get to the merits, let me first address this court's jurisdiction. In assessing the finality of orders, the Supreme Court has told us we must take a practical view of finality. And when it comes to remand orders, this court has made clear that two types of orders that may be labeled a remand order are nonetheless final. Orders that effectively terminate the action, or orders where there is a danger that the party injured would not have an opportunity to appeal later. And here we have both. As for the effectively terminating the action, the order vacates the 2020 approval, giving plaintiffs full relief on count one. And there is nothing the district court could do with respect to count one of the complaint, because all that count one challenges is the 2020 approval, not individual elements of that approval.
That's going to be true often in remands. That is exactly what the plaintiffs asked for. So in that sense, it'll be full relief. But it's the whole rationale of this doctrine is that, well, we'll see what you get on remand. They're going to revisit the issue. And either side, Indiana as well as the other side, will have the opportunity to challenge that decision once it issues.
There will be a new decision on remand, but any future litigation about that decision is not about the 2020 approval. And I think that's one of the critical.
Why does that matter?
So I think that's one of the, in two ways, Your Honor. First, as to when we're looking what effectively terminates the action, we first have to ask, what is the claim on which the district court entered the Rule 54B judgment? And the claim here, as the district court noted, is about the 2020 approval and that approval only, not individual elements who can continue to be disputed or litigated on remand. And I think the second reason goes into, can this effectively be reviewed later? Here, any future litigation is going to concern the new agency action.
But I think the concern is that your argument just describes the exact prototypical case we've said isn't appealable. Every time a district court vacates an action and remands to see if that same action can be justified, that's sort of the baseline situation in which we say it's not appealable. So I think you need a reason that this case is different from that, don't you?
So I think there are two reasons. The first goes to, does this effectively terminate the action? I think given how the boundaries of the actual claim at issue count one, that this is very much like the American Great Lakes case, where there was going to be continued litigation about the rulemaking, but because of how the count on appeal was framed, the court said the order effectively terminated the action with respect to that count. And as to the second piece of it, which is can this be appealed later? Yes, there may be future litigation about HIP in general, but not the 2020 remand. And there's a chance that any future litigation about this may not even occur in this circuit if there is a denial on remand.
But after the remand, if you want to appeal, you can appeal the new proceedings after remand, and you can also appeal the remand order that set it there. So I don't understand why you wouldn't be able to appeal this later.
So I don't think that's true if there is a denial of the approval on remand, because Indiana would be entitled to challenge that in the Southern or Northern District of Indiana. Any appeals would go to the Seventh Circuit. And at that point, I think this action would likely be moot. There would be nothing further to do, nothing further that the district court could set aside.
Precedent for that? Because I don't think that's the way it works. And I think we have precedents that say that you can challenge the remand order.
So I think we cite a Seventh Circuit case in our brief. I think Travis is the name that sort of says that when you have a new agency action, at least in the Seventh Circuit, they're going to consider the old agency action, any litigation about that moot. And I think that shows exactly the dilemma we are in.
But I also it's not uncommon. And this happens often during presidential transitions, that matters are sent back to agencies because the agency says, as I have here, we're going to look at this again. And especially if they say, we're going to make a new decision, as they have here. At a bare minimum, we would hold the case in abeyance rather than rule upon it, because it's a waste for us to issue what everyone knows is going to be an advisory opinion on the lawfulness of agency action A, when they've already said, forget about it. We're going to do agency action B. So I don't understand why we would spend the resources and then, either they come out with a decision before we do, at which point it's all wasted, or we come out of it right before they do, at which point it's all wasted.
Well, I think, Your Honor, that goes maybe to a prudential concern about whether you step briefing in a case or not, but not the issue of finality, which is determined at the time the agency action issues.
Are you happy if we just hold it in abeyance?
Your Honor, I
don't
think
know how that helps the concerns that you're raising. So it seems to me it gets to the practicality, you're talking about a practical effects doctrine here. And if it makes no sense for us to reach out and rule under the arguments that you're advancing, which simply sort of echo the problems with this remand rule.
So I think, Your Honor, that would go to some of the practical concerns about, what happens with future, do you lose the chance to appeal at all? But I don't think it addresses other practical
What do you
concerns.
think will happen to that appeal if we hold it in abeyance and then they issue a whole new decision?
Well, I think
what are the chances we would then say, well, we still need to decide this? Of course we wouldn't.
Well, if it's a denial, I think the court would need to decide this appeal, because that is the.
No, we would advance. There's no point to that. It would get you nowhere. You would still have to do with denial B. It would do nothing to remedy your injury if we say maybe they were wrong about denial A, that it was actually perfectly lawful, because they now have a whole new decision in place.
And then if there's a denial, that litigation might not even occur in this court, which means the district.
I don't understand what the relevance of that point is.
Well, I think it goes to the district court's decision not being effectively reviewed, including, and I think this is significant.
That would be your choice. I mean, or the plaintiff's choice, whoever's choice it is. There's no guarantee that every district court decision ultimately gets reviewed if parties choose to challenge a subsequent agency action somewhere else. That's just how the world works.
Well, Your Honor, I think that we're not saying that every ruling that may come in the course of a case, can immediately be appealed, but rather, one of the significant pieces about this is not just a remand. It vacates the agency action. So there are going to be consequences
What rule are you actually asking us to adopt here? Are you saying that all remands that vacate agency action are not final? Because in general, remands are not final decisions. So what are you saying? Is it because Indiana is a state? Is it because any remand where an agency action is vacated is now final in your view? Like what exactly are you asking us to hold?
So,
This is not just your case. This is going
Right.
to affect a lot of other cases.
so the rule that we think is, that sort of that most accurately captures this is where there is a district court decision that vacates an agency action and the complaint and the relevant count before this court is attacking that specific agency action. It is final and appealable.
That
And if
is a very routine thing that happens in this court. So you're saying that all of these remands, any remand that vacates agency action is non-final. Even though it's being remanded, going back to the agency, there's going to be more stuff happening, but it's final. If it vacates the prior agency action, that's not final in every case in that posture.
So I don't think so, Your Honor. And I think that's just the line between maybe the Pueblo of San Vista case and the American Great Lakes case is it depends on the not just whether vacatur occurs, but vacatur and how the claim at issue is defined.
So it depends on the remedy. It depends on vacator.
Vacatur plus what is the scope of the claim that is at issue. And here, the scope of the claim is specific to a particular action on a particular date, not everything that could be litigated about the HIP program. And I think,
This is a very difficult rule for us to adopt and implement.
well, if there are concerns with that, I think we have a narrower fallback rule
I guess my question is, why would we do this?
Well, I think one of the reasons is because specifically when we're talking about Medicaid, you have a state that is not an ordinary party. It's part of
Is this a Medicaid specific rule you're asking for?
So I think if the court is uncomfortable with the broader rule I just proposed, it would be permissible to have a rule for cooperative federalism programs in which you have an agreement between two sovereigns and both are equally impacted by vacatur of it. So I think that would be the narrow rule. And,
But you're not equally impacted because you can still appeal later after the remand, whereas the government couldn't, the agency couldn't.
Well, I
That's
think
the whole basis of the rules that we have in place.
Well, I think that as the dialogue with Judge Millett illustrates, there is not a non-zero risk Indiana wouldn't be able to litigate this case to conclusion. And that's exactly what the government faces whenever it has a remand. It may well just issue a decision on remand that gets challenged and the government can then litigate the validity of its original action in any subsequent appeal, but there is no guarantee. And that is precisely the problem that we're trying to avoid when it comes to practical finality. Now,
Can I ask you about the practical finality? So if the district court had just remanded without vacatur, what's your position on jurisdiction?
I think we'd be in a very different position. Your Honor.
Of course you are. That's why I asked the
Yeah.
question. So I just want to know yes or no.
So if it's remand without vacatur, I don't think we would be here.
Oh, that's not a legal answer at all. Analyze finality under the test you wish us to apply in a scenario where the district court's decision was just a remand.
So I think it depends on the scope of the claim. If the claim
This
is,
case, if it
so
was
this
just a
case, I
remand-
still think there would be a final decision because the claim is specific to the 2020 approval. And so we're in very much the situation as if the government wanted to appeal. There's no dispute. I don't think that would be final and appealable. So I think we are very much in the same position. Now, in terms of whether there is the same need to appeal, that may not be always the case,
Well,
but
that's Indiana's decision on whether it needs to appeal. So your position doctrinally is not limited to vacatur situation. And you say it's because there's a final resolution of a particular agency action, 2022 approval, which is going to happen 100% of the time when there's a remand. There has to be a final decision on whatever is being remanded.
So, and to be clear, I think this court's established there's two branches of remand orders that are final. One is effectively terminates the action, and that doesn't depend on the remedy imposed. And the second is, is there a meaningful chance to appeal later? And that, I think, is where the vacatur comes in.
Effectively terminates the action is a really weird argument when there's a 54B certification
Well,
that you sought, because the whole point of 54B is that the action is not effectively terminated. This particular claim, or this claim as to this party is terminated, and it makes no sense to wait for everything else.
so I think Yes, Your Honor. I think when I say effectively terminates the action, it's with respect to the claims on which the district court entered judgment.
Okay, well then that is 100% of remand orders, because as to the judgment that's remanded, it will be a decision that there was error by the agency that warrants vacature, or may not vacature, but warrants remand and action by the agency. That action cannot survive unless the agency fixes whatever problem was identified. So I think now we're back in the area Judge Penn was worried about of how we would distinguish this case in a way that wouldn't be now not just remands with vacature, but 100% of remands.
So I think if that is the court's concern, what I would direct the court to is a more narrow rule that addresses this case, is where you have vacatur of an agency action impacting a bilateral agreement between two sovereigns. Either sovereign, the federal government or the state, can appeal.
Okay. And then I wanted to ask you, in that situation, you have put a lot of weight on vacature, and I think for your narrower approach, that's what you're asking us to focus on. In this case, the district court has stayed its vacature order, not just during appeal, but during the remand proceedings, which is about as unvacated a vacature as I can conceive of. And you have pointed out in a letter, well, there is no stay as to the power accounts. That's because you asked for that in your joint motion for a stay from the district court. You agreed to the power accounts not being stayed. So given that the vacature has no practical operation, except in one capacity where you agreed a stay was not needed, what practical effect could we lean on here to say that this one should be treated as final?
So I think when we're assessing finality, it's at the time the order is issued.
That's not the court.
Not
this court's practice. We have assessed finality based on representations and oral argument, and we have that in an opinion. So that binds us.
So I think that goes.
And if you're going to do a practical effects analysis, really, we're going to ignore the most relevant practical effects on which you're leaning on, the consequences of vacature for a partner in a cooperative federal state agreement.
So, Your Honor, to address that more directly, one is when the parties sort of agreed on the contours of a limited stay, it was without prejudice to either party's ability to seek further review. And second, the further review is needed.
You've been allowed to seek further review. You surely cannot stipulate as to how we will decide any issue on that appeal. You have to know that going in.
No, Your Honor, and that's
Right,
precisely why
You're a
there's.
smart attorney. You were aware of the remand rules, so you knew what risks you were assuming.
Well, Your Honor, and that goes precisely to the second piece, which is right now, Indiana cannot operate the cornerstone of its HIP program, power accounts.
It's the count because you agreed to not have those stayed. And that's a you problem. The state of Indiana, not you personally, but that's an Indiana strategic tactical choice and litigation problem. It's also a little hard to call it the cornerstone when it hasn't functioned for 5 years. So maybe 5.5 at this point. So I'm not sure what we're supposed to do with that. Are we supposed to relieve Indiana of its strategic litigation decision and then use that as a basis for finding either a narrow or a broad exception to our remand finality rule?
How we see the issue, Your Honor, is it goes, if at all, to mootness rather than finality. And the case is not moot because there's still a live dispute as to whether Indiana.
Sorry, what goes to mootness rather than finality?
The stay goes to mootness rather than finality in our view.
I thought you wanted us to do a practical effects analysis here. I mean, that's the only way we get into. We can do it because that's where the exceptions to the remand finality rule are. They're practical effects analysis. And so I don't think it just goes to mootness. I think practical effects goes to the practical effects. And it's hard for you to lean on a practical effect as absolutely essential when you agreed you didn't need a stay of that.
Well, there are two practical effects. One is It's going to inform what the government does on remand in terms of the rule it applies. And that's precisely what the government can use to appeal these types of orders. And second,
Sorry, the court's decision is going to inform what the agency does on remand.
correct, Your Honor.
That's 100% of remands.
And that is the exact situation which this court has held the federal government can appeal. And we think when there is a federal state agreement, the same rule should apply to the state as to the federal government. And in terms of,
But why is that when you can still appeal and the federal government can't? I mean, I guess you had said in the Seventh Circuit, maybe you couldn't, but our case law says you can appeal the remand order after the remand. And it's your choice where you bring your appeal, right? So you can just appeal here and then you can appeal a remand order.
so, Your Honor, one thing we can't, and maybe this helps, is one thing that is, I think there's no dispute that no party can appeal after the remand is the decision, not just to remand, but to vacate the order for the duration of that remand. That has to be appealed now or not at all, because however long any remand takes, and this is true in any category of cases, the court can't undo the vacatur for the period, for the years in which the remand in any subsequent district court litigation, any future appeals may take.
But if it's a non-event vacatur, which is what we have here, a stayed
It's a state vacatur.
vacatur. I don't even know what your injury is.
I think
You don't have to change anything you're doing in Indiana.
we do, Your Honor. In order to continue operating HIP without power accounts, the legislature had to enact a temporary piece of legislation that allowed continued operation.
Was that this year or was that in 2020?
2025?
Okay, well, so they've enacted the legislation, so we're good.
No, Your Honor.
But you hadn't been operating them for 5 years anyhow because of the pandemic. You haven't been operating. When's the last time you operated one of these power premiums?
That was before COVID. And the
So,
whole reason that we
before 2020,
didn't
okay.
operate them during that time was temporary legislative changes.
We're a lot of years past COVID. I mean, it's still with us, but COVID crisis, pandemic. And Indiana still chose not to reinstate these power premiums.
Your Honor, we could not, under the terms of an enhanced federal funding package.
That's a choice. That's a choice. Indiana can say no to money.
Certainly, and the agreement was we will not reinstate them while during COVID and any redetermination period, not forever. And now we're in the situation of asking, is this a forever thing or is this just a temporary COVID era thing?
Okay. And you have said, Indiana made the choice that, well, we'll keep doing what we've been doing, no power accounts, while this litigation goes forward and the case is remanded. So Indiana has already made the choice. I feel like I'm repeating myself here that we can do just fine without, maybe it's not our ideal dream, but we can do just fine operating our program as we have for the last 5 years until the remand is over. At which point, it's up to HHS what they want to do about these power premiums. And if it's going to, you say, influence their decision, then you will have an argument. If it influences it in a way you don't like, then you don't want to argue about this one here. You're going to want to argue about the operative decision and say, what were they doing? They were listening to this, in your view, erroneous district court decision. And it's arbitrary and capricious for them to have done whatever they do. That will be your argument. Or they will make a decision and you will be happy as a clam. And Indiana will have nothing to complain about.
Well, I think, Your Honor, that question gets to one of the lingering impactful effects. It is a world of difference under an arbitrary and capricious deferential framework, whether you are the party challenging the decision or whether you are the party defending it. Here, we're the party defending it. If there's a new adverse decision, Indiana would be the party challenging it.
Here's the one where you are challenging it. You want this litigation to go forward where you have to challenge. I assume you'd be happier to defend on the next round if you like the agency's decision.
Well, to be clear, I'm talking about there's a difference between challenging the agency decision, not the district court decision.
Okay, but it's applying the same arbitrary and capricious review that we do.
But as this is a deferential standard, if you are the party challenging the 2020 approval, or
I don't disagree that you're happier as an applicant or respondent in any of these types of cases, but I'm not sure that's a justification for finality. Can I ask you a fact question?
Absolutely, Your Honor.
How many folks in Indiana are enrolled in the HIP program? I obviously aren't going to have, I assume you won't. I'll be very impressed if you have the precise number today, but just roughly.
I think roughly about 600,000.
Okay. Okay. All right. And do you know what the current status of your application for another 5-year extension on the substance use disorder and mental health program is?
Is still pending, Your Honor.
Okay. Okay. Can I ask you, I don't know if my colleagues have other questions or?
I have another question, but please finish.
Okay. While HIP 2 has 2.0, I guess you call it, has been in effect, how many individuals have been either denied enrollment because they couldn't make an upfront premium payment or have been kicked out for not making premium payment?
So when we're answering that question, we have to distinguish between 2 periods of time. One is between 2015 and 2018, in which there was a different version of HIP, and then from 2018 to 2020, before COVID sort of derailed everything, because in 2018, the state made a couple of changes to simplify power accounts and to recalculate how contributions are done, such that for most people, it dropped substantially.
But I just would like to know.
Yeah,
the
so
total
before
amount of people that have been kicked off.
So before the 2020 11 report notes, I think there were in the 2018 to 2019 period, there were about 5,000 that were kicked off, and that's about 1.4% of the total HIP population.
So 5,000 kicked off, but how many tried to enroll but couldn't? Because I take it you have to pay a premium to actually get your first premium to get enrolled.
Yeah, so for the 2018 to 2019 period, there is no data on how many people did not enroll because of the contributions, but that was precisely one of the things that the 2020 report noted would need to be studied going forward, because you couldn't rely on
It's a long time since 2019. So what's the study results? How many people?
So the 2019 to 2020 data I'm not aware of anything in the record that specifically addresses how many people tried to, were interested in enrolling but did not. But if you look at page
2018 to 2020 is what I'm interested. You said you were going to do a study of this
Yeah,
period,
so
it would cover that.
If you look at page 1037 of the joint appendix, it provides the data on how many people were disenrolled in that period for failure to make contributions. It was 5,500 members. That's against a population of about, I think it was about 50, over 500,000 at that time.
Sorry, 5,500
were disenrolled for failure to make contributions.
That's still at, so 5,500, I had 5,000 from you. Okay. But we still don't have, you don't have the number, or it's just not in the record, but Indiana does have a number for how many people were rejected from enrollment in the first.
It's not in the record, and I'm not aware of data.
I thought you said they were doing a study.
No, the report indicated that data would need to be analyzed. I'm not aware of whether the report actually was completed with respect to that, data category.
Is there any reason to think it's lower than the 5,500? This seems really, really, I just, really, you're doing this program in which enrollment is an absolutely essential feature, and you're not keeping track of how many people are not allowed to enroll because of this was a whole point of the experiment, is to test how this works. And so you have to know how many people, not you personally again, but you have to know how many people couldn't enroll because of the requirement to pay premiums. Otherwise, this isn't an experiment at all. And that's a whole nother reason for HHS to be concerned about reauthorization.
So, Your Honor, I think part of this is a timing issue. The 2020 report comes out in April of 2020, at which point there is no longer premiums being charged. And it's, sort of analyzing retrospectively data from 2018 and 2019. I am not aware of whether there was a survey conducted in 2018, 2019 before COVID interrupted
But you
things
said-
as to whether people wished to enroll but did not because of premiums. The only data we have from that is before 2018, at which point Indiana made significant changes to the power account structure to lower
Not the
premiums.
practice of refusing to enroll people who couldn't pay premiums. That did not change.
Correct, Your Honor. That did not change, but the contribution.
What are the pre-2018 statistics?
So pre-2018, and if you look at, the secretary talks about this on page 856 of the joint appendix, that there was 3.1% did not enroll for failure to make, or were disenrolled for failure to make contributions in 2016. That went down to 2.2% in 2018.
How many were not allowed to enroll in the first place?
I think one survey had a number of about 26,000 over a, I think, 18-month period.
Okay. And that survey is a Indiana report, something to commission.
It was an evaluation, yes.
Okay. I'm sorry. Go ahead.
Thank you. So on the question of whether you would have the opportunity to appeal the remand order after the remand, I had asked you about that because our case law says that you most certainly can do that. And you had responded that the thing that's actually final is the vacator. And it just seems to me that if the thing that's final is the vacator, why would you get to actually challenge the remand order, which is what you're trying to do here? And on the vacator order, we have a whole sort of set of legal standards for vacator. And in this case, there was arguments about disruption, et cetera, which is certainly something that should be considered. And the district court considered that and stayed the vacator. So it just seems to me, number one, you're here trying to appeal the remand order when the only thing that you're actually saying is final is the vacator. But in this particular case, the vacator has no real effect. So any arguments you would have had about vacating vacator just really carry no water here because it's all been stayed.
So there's not a separate remand and vacator order, Your Honor. They're part of the same order. It vacates and remands. As to the practical effects, we do think that, the unable to appeal later, that's one branch of this court's cases, and that's where the vacator is significant.
But you have to meet that standard. And so I guess there's two parts of it for you. One being that you're conceding that you can appeal the remand order later. I guess you have to concede that because that's our case law. So the only thing you're relying on is the vacator. But the vacator's been stayed.
It's been partly stayed, Your Honor. And then as to but that's only one.
Said the only reason it's partial is because that's what you asked for.
Yeah, but I think that's only one branch of the cases. The other is, does it resolve the distinct claim in a way that?
But you have to meet both.
No, I think these are two separate cases, lines of cases. On the one hand, you have cases like, long distance telephone exchange, which is talking about, can you appeal later or not in cases that allow the government to appeal when a private party might not be able to? And then you have the branch of cases like the American Great Lakes case where all the parties agreed there would be future remand proceedings on the very rule that the plaintiffs were challenging. But this court said that the plaintiffs could appeal in that case because with respect to, part of the rule, there wouldn't be significant future proceedings with respect to that piece. And that's where we are here.
No direction for the agency to act in the Great Lakes case. There's no direction for them to act and no reason to think that they were going to act. We got the antithesis of this here because the agency has said, we're on it. We're going to issue a new decision.
So Your Honor, I think that may just go to how you're defining the claim.
But it isn't like American Great Lakes. It doesn't fall within that exception.
But I think and this maybe just brings back to, I think, what is the narrowest way to resolve that when you have an order that remands or vacates and remands, either way, that agency
That's the narrowest way. So you better
an agreement between two sovereigns, the federal government and the states, either party, the states or the federal government, can appeal.
Even when the two sovereigns agreed to have it stayed.
Yes, Your Honor.
I think we've kept you up a little bit longer. Thank you so much. We'll give you some time for rebuttal.
May it please the court, Maxwell Baldy for the federal appellees. My friend offered, I think, like 4 different potential rules for why this case might be appealable now, why there might be appellate jurisdiction. I don't think any of them work, but I want to talk through them. The first was the idea that if there is vacatur and final resolution of a claim, but this case has a lot of this court has a lot of cases. Pueblo of Sandia is a great example where there's vacatur and remand and there's still no appellate jurisdiction because that is inherently an interlocutory order and it can come back and be resolved and the remand order will merge into the final judgment.
Why isn't it? I mean, we have this strange exception that the government can appeal for practical reasons. It doesn't become any more final when it's the government versus Indiana appealing. But in the area of these cooperative state federal programs where essentially what has been invalidated is a contractual agreement between the government and a state. And so the state's half of that contract is just as much broken as the federal government's. And if you had true actual vacatur in effect, you know, you all are making your decision making, but you could have a state that's left with no Medicaid program. And it's going to have to deal with that while the remand is ongoing before the agency. And that would be extraordinarily disruptive. And you could halt a Medicaid program, could throw it into turmoil. Why wouldn't, if we had actual vacatur effects in a case involving, so you'd have to have a remand with vacatur. There'd have to actually be vacatur effects. And it involves a cooperative state federal program where what is vacated is the contractual arrangement. Why wouldn't it make just as much sense to allow the state, whose ox really is deeply gored in that situation, to appeal just as much as the U.S. government? Because whatever they appeal they can have later, they will have dealt with a year or two of having to completely reorder and revamp their entire system, or just not have Medicaid for a year or so.
Yeah, let me address that in 2 parts. First, sort of the premise that Indiana might not have Medicaid. They would still have a state Medicaid plan. They would not be able to run their demonstration program, and there might be features under state law that require them to change some things. But, you know, I don't think that it's accurate to say that
It's
Medicaid would disappear in Indiana.
Maybe I'm wrong. If you have a demonstration program, at least one like here that is what made the whole expansion possible, that's a lot of change. Let's assume their basic plan would just go forward. There's still tens of thousands, maybe 100,000 people that are thrown off in their view. Again, assuming there were actual vacatur here. Let's imagine a different state, an actual vacatur order that's not stayed. And as a result, 100,000 people who have been able to receive Medicaid under the experimental program will immediately be thrown off when that experiment goes away. Can they appeal to or not?
I think that would be a compelling reason for the district court to remand without vacatur or to stay a vacatur order.
But if that hasn't happened, why aren't they? This is a practical effects. The only reason the government gets to appeal is practical effects. And so why would
I'm not quite sure that's true. So in Pueblo of Sandia, this court described the rule that the government gets to appeal in that exception as an application of the collateral order doctrine, right? It said remand rules as a category are not final, but because there's an asymmetry, the federal agency gets to appeal because there's no way for it to take the case back to court.
But it's just definitely not meeting the Cohen factors because it is not separable from the merits. It is the merits that you're appealing. Well,
no, what we're appealing on remand, what's being appealed on remand is this question of, you know, what standard we need to apply or what additional explanation we need to apply.
The merits of the case. This is count 1 in the case. So you can, if you had chosen to appeal on the merits, then you would be arguing the merits of the district court's decision and of the ruling on count 1 of the complaint, would you not?
So,
in fact, you have done that in your brief here.
I understand what you're saying. I can't change the analysis that this court has in its precedents calling
I
it an
get that.
application of
That's
the
on,
collateral order
that's problem.
doctrine.
That's on us.
Yeah.
But it's not, I don't know that we can sort of say Indiana's out just by looking at Cohen factors.
So then I would point to, if you're talking about the practicality and you're looking at why the rationale for why the federal government gets to appeal here is not that it's that it's a sovereign or that it has particularly strong interest or that there would be particular effects. The rationale is done sort of on a categorical, not case by case basis. And it's based on the idea that the agency can't challenge its own actions complying with the remand order. So if the agency thinks on remand, it's been instructed to do something contrary to the statute and it has to comply with that order and it reaches a new decision and puts it out, it might just be stuck with that. If no other party brings that to court.
Can we separate the vacature from the substance of the remand order? Like, why doesn't a vacature order meet the Cohen factors? It's conclusive. It resolves an important question. If thousands of people are going to be thrown off Medicaid, and it's effectively unreviewable on appeal. Like, why can't a vacature order be appealed?
I don't think it's accurate to say that it's effectively unreviewable on appeal. It would, all interlocutory orders merge into a final judgment. And
But it's effectively unreviewable because once you vacated it, by the time you come back after remand, all these people have lost their.
So I would look to the
insurance.
example of like a preliminary injunction, which Congress had to create a separate provision. It needed 1292A to make preliminary injunctions appealable. It wasn't just they fit into 1291 because they're effective, the effect of the preliminary injunction halting some action during the pendency of litigation is
Preliminary
effectively
injunctions
final.
are hard to fit under Cohen. I'm just saying, why don't vacature orders fit under Cohen?
Well, I'm saying I think they're in many ways they're analogous, right? It's a coercive order telling.
Well, preliminary injunctions deal with the merits, whereas a vacature order has a sort of a different set of legal things that are more based on practical effects. It's like the Allied signal test is not based on the merits of the action, whereas preliminary injunctions are. So it's separable. It's an important question separate from the merits.
I suppose so. If we were to look at this sort of order, which in the same sentence or the two sentences in a row vacates and remands, what I would say is that you look at cases where you have vacatur and remand, like Pueblo of Sandia, and the court has reached the same result and said that these are separate. That the fact that there's sort of two dispositions doesn't change the fact that it is a remand order. And here's the
Well, maybe
point
they
of
didn't make the argument there that the vacature has all the effects that this one does.
I mean, it in that case,
So I guess we would have to look at this. If it's Cohen, it would have to be categorical. So we would have to say vacature orders are a category of things
right.
that it's important that we allow.
And that's another reason why I think the cooperative federalism idea doesn't work, because that's sort of party specific and it's specific to the equities of a case. Again, a great reason to stay a vacatur or to not vacate, but not necessarily sort of the categorical analysis that wouldn't just open up a whole wide swath of orders coming up every time.
Finality different or the same as Cohen? Because we've already talked about you got a huge problem if the government even appeal and if we have to go through the Cohen factors. I don't know that the Supreme Court has said that's how we look at practical finality, but maybe you've got a better read on it.
So, I mean, I think we don't go through it in every case because this court has just said as a category, this exception exists. And, if we were to litigate it from first principles.
There's 0% of times where the government appealing the merits of the district court's decision would be separable from the merits.
Let me give you an example that I think might work. So take a case where take a FOIA case where there's an issue of adequacy of the search and it's remanded for a new search and the government appeals. That is not the ultimate merits question of whether the government has, disclosed documents properly, made proper withholding. It's a question of sort of this partial question of what sort of search needs to be done. It's not a final resolution.
That's the merits issues we decide in FOIA cases all the time.
It's a merits issue, but it's not a sort of the final end all be all merits question, right? You would still have a whole lot of other analysis in a FOIA case. And I'm suggesting
And has Cohen ever said I'm not even sure how we decide what the final be all end all question is, because the answer to what documents you get is going to depend on what process the agency did or is supposed to do. So I'm not sure I understand that test.
Um,
I'm just actually more doctrinal question. I know this is,
Yeah.
I mean, I've all been wrestling with this, I think, but it seemed like your approach was that there is no practical finality doctrine. There's finality and there's Cohen. Okay. So if there is, are there three categories or two? Is it finality, Cohen, practical finality, or just two?
I think you can look at finality in a practical way, and there are cases where, the kind of cases where courts wrestle with practical finality are things like the court has resolved most of the case, but there's like a lingering fees issue, and there's been any number of Supreme Court cases trying to figure out what sort of fees qualify. There are Supreme Court cases about, when they review state court judgments and the state Supreme Court sends it back to the state trial court for entry of judgment. The state court has said that's practically final. I don't think that's the sort of circumstance we have here where, again, the district court resolved very little here. It certainly said that this was that the approval wasn't adequately justified, that the secretary didn't look at the data and explain his decision in enough depth. But the district court also said, I'm not looking to the reasonableness of the decision. I'm not looking to the underlying data. I'm reaching this decision solely on the basis that there's just not enough here in this explanation. Go back and try again. And the agency has said that it will go back and reevaluate it. And that's, I think just a classic remand. And to the extent that we're talking about the practical finality in this case by itself, I think, Judge Millett, as you pointed out, the stay of the vacatur does a lot of work there, because there really aren't practical effects other than the ability to charge premiums for power accounts and HIP Plus.
Can I just ask you to clarify what you think the rule is that our cases announce? You're basically saying that, and this might be right, the practical consequences, bad, good, and different, are just irrelevant to the question of appealability. The question is just, can you appeal after further proceedings on remand? And that's the end of the story.
I think that is correct for the appealability of a remand order. The exceptions that exist are the government, the federal agency that rendered a decision can appeal because it would have no other opportunity to seek judicial review. That's Sierra Club, Occidental Petroleum. There's the exception for when the only task left is ministerial. There's a remand with sort of instructions and there's nothing left to do. But I don't think that.
Yeah. So we also have this stray, I understand that. We also have this language in our cases suggesting that it's okay because the party who's appealing now can appeal the remand order later. And it seems to me it's really hard to understand in practical terms what that means in a case like this. This doesn't mean necessarily this becomes appealable, but anytime you remand for more explanation, and then the agency gives a new explanation and either grants or denies what the party wants, they're not going to appeal and in this case come back and say, well, don't worry about why they denied it in 2026. They gave enough reasons in 2020. There's no way we would approach that case that way, would we?
Well, so there's the district court's analysis binds the agency. The agency can't go back and say, we're going to ignore your order. And so.
And later, Indiana can't come to court and say, don't worry about anything that happened on remand. You just need to rule that the district court in 2024 was wrong. The initial approval was okay, and forget everything else that happens.
That's correct. But Indiana can say in that challenge, the agency's decision imagine that it went back to the agency and the agency rejected the application. Indiana could bring it back to court and say, we think that the agency was wrong to challenge it, but it could also on appeal say the agency flipped its position and got it wrong because it was bound by this faulty remand order where the governing legal rule that it was required to apply was wrong. That's how it brings it back to court.
Position doesn't make the agency wrong.
No, but Your Honor, if the agency were to,
An agency could approve or not
if
approve.
the, yes, and I'm just suggesting that the option be open to Indiana to argue that the agency was boxed in by this rule of decision that was simply wrong, and that's what it applied.
I think just.
And so my only point is that these questions can come back to court. That is the point I'm
Really,
trying to make.
that one can't. I mean, the point is, as Judge Garcia was saying, is that if we come up here on a new decision where the agency has done a whole bunch of analysis and given, an ideal reasoned explanation for a decision to disapprove, we wouldn't say you have to approve. All we would say is, well, was that reason? We wouldn't go back and go, even if the prior one was perfectly reasoned as well, and the district court was wrong, that really doesn't matter, does it? As long as the decision before us is reasoned.
So let me take an example from this case where the district court, I want to be careful to not box in how the agency interprets the district court's order, but I think there's a way to read the district court's order to say that the agency shouldn't be looking to health effects. I'm not trying to take a position whether that's what it in fact says. If the secretary were to enter a new decision and say, well, I can't consider health effects under the terms of the remand order, and therefore I don't think there's enough here to enter an approval, that's the sort of thing that Indiana could challenge. But yes, with every case that is remanded to get a new decision, to get further explanation for additional proceedings, there is a new decision and you will look to that decision. But
So you're basically saying if there's a wrong legal issue that the district court determined that guides the remand, then Indiana will be able to challenge that.
That's correct.
As part of
That's correct, Judge.
You know what they also could have done is ask for a 1292B certification if there actually were a controlling question of law in this case like that.
Yes, that's the mechanism Congress created for this type of issue.
Can I ask you two questions? One just factual. Do you know what the status of HHS's review on the remand is, or if there's any, may not, but if there's any rough timetable or anything like that?
So I know that it is before them, and I understand that at the moment they are waiting to see how this plays out. I'm not representing that they won't act because they haven't told me what they're going to do one way or
Are they
another.
acting on waivers during the shutdown at all?
I don't believe so, but I actually,
So they're waiting for two things now.
yeah, they're waiting for a couple of things.
Okay. Do you have more questions? I was really curious about about 2/3 of your brief are spent on the merits, arguing that if we do find jurisdiction, we should vacate the district court's order. Did you guys file a notice of appeal?
No.
I'm assuming you and the Justice Department are acutely aware of boundless precedent from the Supreme Court and this court, holding that a party that wishes to change the judgment of the district court has to either file a notice of appeal or cross appeal.
Yes, Your Honor.
It has to get that filing approved and authorized by the Solicitor General. The Solicitor General authorized that part of your brief?
The Solicitor General has reviewed the brief, yes.
Has the Solicitor General authorized an appeal?
No, the government did not appeal.
Then you can't. Why is that? What is your rationale for why that argument is there without filing an appeal, notice of appeal?
So, Your Honor, the government is not seeking to invoke this court's jurisdiction to disturb the judgment of the district court.
That's a conclusion of your brief?
What we are saying is that if you were to reach the merits, that we are presenting our views on the proper way.
If we find jurisdiction.
Yes. If you find jurisdiction, if some parties invoke the
Then
jurisdiction
you
of
had
this
to
court.
file a conditional cross appeal. I mean, we've held, Supreme Court's held 100 times. A party can't stand there at that podium and ask us to change the district court's judgment without filing an notice of appeal or cross appeal or petition, whatever the case may be. And you don't get around that. This isn't an alternative ground for affirmance that you're advocating. And if the Solicitor General is going to do that, Solicitor General has to own it and sign a piece of paper that says appeal or cross appeal and make that final decision. I don't care if someone in the office reviewed it. It has to be authorized. And you're telling me that that argument to change the district court's judgment was not authorized by the Solicitor General.
I am telling you that there is not a, slip order in the archives in OSG saying, I authorize
It's
appeal
not
in
an
this case.
authorization by the Solicitor General to seek to overturn the decision of a district court. Conditionally or otherwise.
Your Honor, the government has not appealed.
You have a whole 2/3 of your brief is an argument that we define as an appeal. Please change the district court's ruling.
If we had filed the other version of the brief where we had said nothing on the merits, the chances that I stood at the lectern and got a whole bunch of merits questions that we hadn't briefed and hadn't run through an agency process and were ordered to do supplemental briefing, it's not like unreasonable.
That's why you file a conditional cross appeal. This is not alien stuff, but you've told us it's not authorized by the Solicitor General. I don't know why we shouldn't strike that entire 2/3 of your brief, even if we get to the merits.
If you wanted to, you can also, if you wanted to view it as an amicus brief, you could. If you want to view it as whatever, this is the government's position. The court is free to consider it or not.
Well, I'm very concerned about this process issue. That this is just pretty settled law, and it seems like it's circumventing the rule of Solicitor General authorization for a decision. I mean, the whole point of that process is to police when the government chooses to seek to overturn a district court's decision or not.
Yeah, I want to be careful about how I characterize internal government deliberations, but what I will say is that the Solicitor General decided not to pursue an appeal in this case.
That seems to
Two different deputies Solicitor General have also reviewed the various filings the government has made.
Okay, but I think the fact that the Solicitor General chose not to appeal means that you are not allowed to argue for a change in the district court judgment. As if there's something wrong in my analysis, let me know.
The
Supreme Court said without SG authorization.
all I can say is that, the SG wanted the views in the brief put before the court, and the court can consider those or not.
Okay.
All right.
All right, thank you.
The appeal should be dismissed. Thank you.
May it please the court, Erica Turrett for Indiana Medicaid beneficiaries, Monte Rose Jr., Chelsea Lang, and Emily Rames. In 2020, the Secretary approved an unprecedented 10-year extension of a Section 1115 project in Indiana. In doing so, he brushed aside years of uncontroverted record evidence demonstrating this same project had resulted in tens of thousands of low-income Hoosiers losing their Medicaid coverage. This morning, I have two key points I'd like to address. First, for the reasons the government stated and as explained in our brief, this panel is bound by this court's precedent dictating there is no jurisdiction over Indiana's appeal. As your questions to Indiana made clear, this is a routine occurrence for this court. This court's precedent is manifest in Indiana's arguments as to why it should be able to end run a categorical jurisdictional rule or unavailing. Second, if you do proceed to the merits, Judge Boasberg correctly determined the Secretary failed to adequately consider Medicaid's core purpose of providing coverage to those who cannot otherwise afford it. That makes the Secretary's approval arbitrary and capricious under the Administrative Procedure Act. This is the same textbook APA error the Secretary made when he approved Arkansas Section 1115 waiver. An approval this court held was arbitrary and capricious in Gresham v. Azar. There's been a lot of discussion about jurisdiction this morning, and unless this court has further questions, I'd like to address Judge Millett's questions about coverage loss to Indiana. If you look at JA 1200, it makes clear that between 2015 and 2016, 46,000 people in Indiana were never enrolled because they could not pay a premium. An additional 13,000 people in that period were terminated from their coverage for not paying premiums. That's a full 29% of people who could have been denied coverage were because of non-payment of premiums.
Do we have any? Oh, please go ahead.
Then on JA 1029, we go into the data from 2017 to 2018. In that period, Judge Millett asked Indiana whether the state had looked at the number of people who were never enrolled, but for not paying a premium. The state did not study that during that period, but for people who were actually terminated from coverage, it was an additional 26,000 people terminated for non-payment between 2017 and 2018.
Have there been any studies of, because that's the one that involves HIP 2.0, that time period.
Sorry, Your Honor?
Is that second time period involves HIP 2.0? Do I have my dates right?
Yes, HIP 2.0 was approved in 2015.
Right.
So that whole time period covers HIP
And
2.0.
so, did it take effect in 2015 or 20? When you talk about statistics from 2015 to 2016, does that include HIP 2.0?
Yes, that's all under HIP 2.0.
Okay. All right. Why are there statistics of how many people were denied coverage in after 2016 to 2020, I guess?
Yes, we have statistics from 2015 to 2018. And we have some initial data from 2018 to 2020, but as Indiana indicated, that data is smaller. But numerous commenters alerted the secretary to the fact that the barriers posed by premiums continue to be present. And you'll also see that type of information in the amicus brief from the American Public Health Association.
And then I had a question with respect to the retroactive coverage issue. So Mr. Rose says he has medical debt from before he enrolled in HIP due to emergency room visits, but doesn't say whether any of those visits were in the 3-month period that would be covered by retroactive provision. And Ms. Rames says, if I'm saying her name correct, Rames has unpaid bills from before she was insured with HIP, but again, doesn't say that they were incurred within the 3-month period. So I'm trying to understand whether you have demonstrated standing as to that particular argument.
Correct, Your Honor. First, as Judge Boasberg explained, you don't need to reach that in order to find that the plaintiffs have standing to challenge HIP as a whole. But with respect to retroactive coverage in particular, if you look at someone like Ms. Rames, she could be terminated for non-payment of premiums because her income is above 100% of the federal poverty line. Because she has ongoing health issues, that means that there's a substantial probability that if she were terminated, she would undergo expenses in the 3-month period following termination. So in our view, that's the correct way to view.
I thought, so since there's no more lockout period, I thought if she gets terminated on Tuesday, she can apply again Wednesday.
Yes, Your Honor, but not if she can't afford to pay the premiums. If this waiver approval in totality, including with respect to premiums, were to go back into place, that would mean that someone like Ms. Rames would need to pay a premium in order to be back enrolled. And so our position is that if she cannot afford to pay premiums, she would go uninsured.
I think that goes to the premium requirement issue, but so it sounds like you do not have at least a good faith allegation that either of them has medical bills that cover the actual 3-month period that preceded their enrollment.
Correct, Your Honor.
But so you're arguing, I guess, a substantial risk that if so far they've been paying their premiums and they're still in, but if in the future they can't, then they'll be kicked off, and there's a risk of that. And then there's another risk that during that time period they're kicked off, they will incur medical bills.
Your Honor, to take a step back, the plaintiffs haven't had to pay premiums, as this court noted, for 5 years since 2020. So having to pay premiums now again would be a significant departure from the status quo and a significant expense. And, no plaintiff could guarantee for sure that if terminated from coverage, that they would have certain expenses within that 3-month period. But we think under this court's precedent, if you have ongoing regular health needs that you frequently receive medical care for, then there's a substantial likelihood that within 3 months you would have that.
Precedent from this court?
I can pull that, Your Honor.
Or you could send it later if you want. I don't want to delay things.
Yes, Your Honor. I would point to cases like NBXL Ray Peacock v. District of Columbia from 2012 and Association of American Physicians and Surgeons v. Sebelius from 2014.
Are those in your brief?
Sorry?
Are those in your brief?
Yes, on page 24 of our brief.
Got it. Thank you. Thank you very much. That's helpful. Uh, why wouldn't, if you have, I'll ask you the same question on jurisdiction. If you have as here a cooperative state federal program that produces a contract between two parties, US government, state government, and that contract is vacated by a court order. And let's imagine it's hypothetical state X, and they have an experimental program to address treatment of particularly expensive types of cancer. And so because the cancer treatments are so expensive, maybe some of them experimental themselves, that they want to let people in who maybe they don't want to go limited. They want to expand the number of people that can be covered by this. And if vacatur would terminate that experimental program. And so while the remand is ongoing, people are not receiving cancer treatments or some other thing in dialysis or life-saving prescription medications. Doesn't that warrant, isn't that about as practical a reason for recognizing finality as we could have?
Your Honor, taking a step back, I think it's important to keep in mind that with respect to vacatur here, that's the standard remedy under the APA when you remand. So if we were to treat vacatur, remand with vacatur and remand without vacatur differently, that would cut a huge hole in this court's precedent regarding non-final remand orders. I'll also say with respect to that hypothetical, I would consider this court's decision in Millett Therapeutics. There, the FDA had approved a new drug. The district court vacated the approval and remanded the decision back to the agency. Nexus Pharmaceuticals, the intervener, came in and talked about all the harms. It would not only not be able to market the drug during remand, it said, but also that ill patients would go without access to the treatment. And this court still said no jurisdiction.
Yeah, but when the FDA makes an error in approving a drug, there may well be concerns with safety and effectiveness. There's no safety and effectiveness of a drug analysis or cancer treatments here. So I don't understand. It doesn't seem to present the same. That also wasn't a cooperative state program. Was like, you can't take the government side of the contract down without taking Indiana's side down as well. And so if they actually came forward and made a showing, people will die, or people will have extraordinary health impairments. Say, oh, sorry, we have this remand rule, and that's not final enough. You can talk about that on your appeal later.
Your Honor, we don't think that vacatur is determinative of the jurisdictional question, and this court has never viewed remand orders differently on that basis. We also think it's important to consider that here, this is about a Section 1115 approval. It's not about the underlying Medicaid agreement between the federal government and the state. As the federal government indicated, that would be the state plan. So it's not as if vacating a Section 1115 approval disturbs the underlying Medicaid
My
program.
hypothetical would disturb this program, and the state's going to come forward and say, this is hugely consequential.
Understood, Your Honor. And we think this court's rule is that a remand order that returns the core dispute to the agency to reconsider the decision for significant further proceedings is a categorical rule. We think practicality considerations are baked into the court's exceptions. And in your hypothetical, I don't see one of those exceptions applying.
We haven't recognized an exception like this yet, but initially we hadn't at all. And then we recognized one for the government. And then we recognized one for, well, the agency's not going to do anything, so they won't be able to appeal later. So we have recognized practical exceptions. Have we said that list has been exhausted?
No, Your Honor, but the government's exception is based on the idea that it will never be able to appeal its efforts to comply with the remand order. And the practical exceptions all are in cases where the core dispute was not returned to the agency for further proceedings, or the agency wasn't going to act. So you, in the dialogue with Indiana, explained that this court has said that if the agency concedes an oral argument, for example, that they're not going to act, that would warrant an exception. That's what happened in Ray long distance telephone, for example. So in all those cases where practicality as an exception has been baked in or recognized by this court, it's instances where the agency was not going to reconsider the decision on remand and where the court left discretionary room for the agency to act.
Questions? All right. Thank you very much, counsel.
Thank you, Your Honor.
Mr. Bardo, we will give you 3 minutes for rebuttal.
Thank you, Your Honor. 2 points, one on jurisdiction, one on coverage. On jurisdiction, all parties accept that this court would have jurisdiction over the appeal if the government had filed a notice of appeal. We think that same rule should apply to states where there is a decision impacting cooperative federalism program. They're just as affected by the federal government, if not more so by any decision, and like the government, face the prospect of not being able to appeal if, for example, on remand, there's a new decision and for whatever reason, the plaintiffs decide not to challenge it. And I don't think that because of that parity, I don't think the stay factors into this analysis, but I would also just remind the court that if the partial stay is going to factor in, that does create a perverse incentive to seek disruption to create jurisdiction. On the coverage point, all of the data that was the plaintiffs have talked about was either before 2018. That overlooks that, as page 882 of the joint appendix notes, there was a substantial restructuring of the power account structure in 2018. That means you can't rely on pre-2018 data. And while there was an expectation that the secretary expressed on pages 755 and 756 that this issue would continue to be studied, at the time the approval issued, we now were into the COVID era where, due to both special COVID era rules, as well as just the general dissimilarity in circumstances in society, where it was not possible to continue testing this aspect of the program until COVID ended. I think that's
Have you resumed testing since COVID ended?
we have not been able to, Your Honor.
Not been able to, or just haven't?
We've not been able to because the special COVID era rules sort of lasted right up until we got the district court's decision in this case. And then at that point,
Wait, you did special COVID funding?
So there was special COVID legislation that says states could not disenroll.
There wasn't a reason you couldn't have done a study.
Based on funding that was accepted at the beginning of COVID, there was no longer any contributions to power accounts being charged during that period. So the issue, there wasn't a factual material to
Financial
study.
decision was made.
Correct. And then when COVID, those rules ended, we had the district court's decision that vacated the portions of the waiver that would be needed to implement those contributions and therefore have data to test.
Okay, and then did you just say that the data from 2018 to 2019, which is years after HIP 2.0 was adopted, doesn't track the operation of HIP 2.0? Did I, or
I'm sorry, pre-2018 data, which is all the data that the plaintiffs are pointing to, can't be used to assess HIP 2.0 post-2018 because in 2018, there were major structural changes done to power accounts that had the effect of lowering premiums to $1 for about half of the population, and that simplified the whole structure to address some of the concerns that commenters had raised about sort of the pre-2018 operation.
Mm-hmm. Any questions? All right, thank you so much to all counsel. The case is submitted.
Case number 25-1039. Music Choice Petitioner versus Copyright Royalty Board and Librarian of Congress. Mr. Fackler for the petitioner, Ms. Mundell for the respondents, Mr. Hellman and Mrs. Curry.
Good morning, Your Honors. May it please the court, Paul Fackler for petitioner Music Choice. And I'd like to reserve 2 minutes of my time for rebuttal, please. Your Honors, this appeal relates to the royalty calculation rule applicable to a statutory license in the Copyright Act that is available to business establishment services, or BES. The BES are essentially digital radio services that transmit music programming to retail and other commercial establishments. So those businesses can play music in the background while people shop there or otherwise visit the business. In the reopened rate-making proceedings below, the Copyright Royalty Board interpreted the gross proceeds definition in that rule in a manner that's completely inconsistent with the plain meaning of the actual text of that regulation. And it's for that reason that Music Choice asks this court to vacate the ruling. Now, I understand that Your Honors have some threshold questions about how we got there and how we got here, and I'm happy to address those briefly to start, given that it's on Your Honors' minds. Way back in 2019, Sound Exchange sued Music Choice claiming underpayment of its BES royalties. Those claims were based on a dispute between the meaning of the gross proceeds definition in this regulation. After filing that lawsuit in the district court, Sound Exchange asked the court to invoke primary jurisdiction and refer, as that term is used in primary jurisdiction, the threshold interpretive issue to the Copyright Royalty Board. Music Choice opposed, citing both the plain language of the regulation and also the prejudice to Music Choice and the likely delay in such that sort of referral. There had only been one prior instance of a similar referral, and it took many years to get a ruling. 18 months later, the district court finally issued its ruling invoking primary jurisdiction and issuing the referral and staying the case. At that point, Sound Exchange filed motions in front of the Copyright Royalty Board in 3 separate old BES proceedings that had already been closed to reopen those proceedings and handle this referral. The Copyright Royalty Board agreed to reopen 2 of those 3 proceedings, and then about 3 years later issued its decision interpreting the rulings. At every step along that long process, each party invoking primary jurisdiction specifically cited the Copyright Act's Rule 803C4, continuing jurisdiction of the copyright royalty judges, as the sole grounds for jurisdiction for the CRB to answer these interpretive questions. So Sound Exchange repeatedly cited that rule and the first part of C4, and only that rule. The district court cited the cases requiring the district court to find that the agency would have jurisdiction to open proceedings to answer the referral and relied on C4. And of course, the Copyright Royalty Board itself, when it issued its final ruling, cited its continuing jurisdiction under C4. Now, for some reason—
Where did it do that?
It did that—
That would simplify things, but I haven't seen an explicit reference to C4 in this decision.
Okay, in the CRB, in Joint Appendix 114 and 115, Note 6, you're right, Judge Garcia, that they didn't say specifically 803C4. What they did was they cited their continuing jurisdiction, and they cited to the Register of Copyrights ruling on the scope of continuing jurisdiction. And if you read the register's ruling, and this was from that prior Sirius XM proceeding, what the register ruled was that the first part of C4 was the ground for jurisdiction for answering these sorts of interpretive referrals. So it's not really clear why the judges, when they finally got, in all other instances with the district court and Sound Exchange, they cited the exact,
Sorry,
yeah.
can you explain? This language just seems pointedly only saying we have jurisdiction because we did it once before.
Well, in 115 note 6, I think that they are the only place that they invoke any jurisdiction. And again, in the context where both the district court and Sound Exchange specifically argued that jurisdiction to them, this is their only reference to why they have jurisdiction to issue the ruling. And in note 6, they cite as the basis of their continuing jurisdiction, they reference the register's ruling. And they're adopting that same ground. I don't respectfully, I don't think that there's any other way to read what they're saying in that footnote other than this is where we're getting our jurisdiction, which they have to do. And that was the only ground that the register gave in that ruling as to why the Copyright Royalty Board has continuing jurisdiction to consider ambiguous terms in their regulations.
Am I right that the two proceedings that were reopened were settlements?
Yes and no, Your Honor. They were proceedings that were opened. There was a controversy declared. There was a notice of commencement of proceedings. There was a request for parties who wanted to
I
participate.
understand that. I'm asking, were they resolved by settlements?
The proceedings were ultimately resolved by settlements. Yes, Your Honor.
Right. And so there was no, when there's not a settlement, you have to have this formal proceedings where the board then makes a determination.
Well, yes, there was, Your Honor, because the way that it works, there are two different types of proceedings that the Copyright Royalty Board can handle. One is called a distribution proceeding, and the other is a rate-making proceeding.
Mm-hmm.
They have different processes. In a distribution proceeding, and the board cites this independent producers group case as an example from 2014, where this court held that a particular order of the Copyright Royalty Board was not appealable to this court. That was a distribution proceeding. And the way that those work is the royalties are paid into the Copyright Office, not to Sound Exchange, right? And the claimants, the only dispute is whether the claimants who are entitled to a share of those royalties, they all file claims on a periodic basis with the Copyright Office. And what happens is every year, the Copyright Royalty Board looks at those claims, determines whether there's a controversy. In other words, whether there's a dispute between the copyright owners as to how to whack up those royalties. If they determine there's no controversy or dispute, there's no commencement of proceeding. A notice goes to the Register of Copyright saying, please just distribute the royalties pursuant to these claims. And then there's never a notice of commencement. It's different in the rate-making proceedings, which is what these are. In the rate-making proceedings, there's always, every 5 years, they issue a notice of commencement of the proceedings. The parties then file their notice of intent to participate. There are preliminary things that go on related to setting the schedule. Then there's a negotiation period. And the case can settle then or anytime after.
And it has been settled
Yes.
then.
Yes, but once it is settled, here's another difference between distribution and rate-making proceedings. In a distribution proceeding, the board has no authority to review the settlement terms. It has to just implement them as they're given. In a rate-making proceeding like these, the court has an independent obligation to review the settlement terms for reasonableness and then implement those terms, if found reasonable, in a final determination that is then published in the Federal Register. So in both of these
Does that have precedential effect? Like the parties settle and then the board approves, and is that precedential?
Yes, Your Honor. That is then binding on all licensees, whether they participated in the proceeding or not. Those rates and terms are then in effect for the next 5 years of that.
So if parties agree on a particular interpretation of a regulation or et cetera in a settlement, and it goes into effect, then that becomes the actual interpretation of that regulation?
I'm not sure I understand fully the question because typically
I'm asking, like, if in a settlement negotiation, there was a dispute on the definition of gross proceeds and the parties reached some kind of a settlement, like this is what it means. and then the Copyright Royalty Board approves that settlement. Is that the definition or the interpretation that
Well,
the Copyright Royalty Board adopts then?
yes to the definition. I have to say no to the interpretation, but because the way the settlements work, or there's no real way to agree on an interpretation in these settlements. What the parties agree on are what the regulations will say, the text of the regulations. So if the parties are negotiate or believe that there's an ambiguity or have a disagreement on what the regulations mean, what they would be doing is negotiating to how will we change that, and can we agree on a way to change the terms to resolve that ambiguity. That never happened in this case.
Why would you have to do that? Why wouldn't you just agree that for purposes of this settlement agreement, gross proceeds means X, Y, and Z?
Yes, and that is exactly
That's
what
not changing the regulation.
I agree, Your Honor. I was merely just trying
That's
to
an
respond to.
interpretation. That's an interpretation.
Oh, okay, but all that would not be in the settlement agreement, and that would not be
Why not?
in. Well, having done several of them, it's just not normally in the settlement.
I get you haven't done it before. I guess
Right.
we wouldn't be here if you had, but I don't see what in principles of settlement agreements that would preclude parties from saying, for purposes of the settlement agreement, we all agree that gross proceeds means X, Y, Z.
I think the reason that wouldn't happen, Your Honor, is because the settlement agreements themselves are not typically made part of the record. What is made part of what is issued in the federal regulations is here are the terms, the terms of the rules that the parties have now agreed to, and we're going to put those into the CFR. Okay. I don't disagree with
I
you,
don't
Your Honor.
understand. One, I don't understand why you couldn't do it. And two, whatever, you have a contractual relationship that could be enforced.
Well,
Doesn't have to be to be an enforced contract.
I agree, Your Honor, if I understand the question, that the parties could enter into settlement agreements like that. And as long as that part of the settlement agreement was made part of the public record, so other licensees knew that was part of the settlement. But, in my experience, it's a much better approach to just change the regulation so there's no ambiguity, and then you don't have to discuss.
What do you mean by change the regulation?
Well-
The terms of the agreement that's filed in the Federal Register changes the terms of the regulation?
Yes, the settlement can either roll over the existing terms and just change the rates. But what you're always working off of in these, after you're past the first rulemaking proceeding where the terms are initially set, from there on, you're starting with the old terms and you're saying, do we need to make any changes to these? Sometimes all that you change are the royalty rate, right? The percentage of revenue in the case.
Can you make this concrete in the context of this BES term and gross proceeds?
Yes.
What did they decide in the settlement agreement about gross proceeds, and what does that mean?
Okay, so in the two proceedings that the board reopened, I do not believe there was any discussion about that provision and what it meant, or even any disagreement among the parties.
So that then in reopening, they can't be clarifying an ambiguity if it wasn't addressed in the first determination, can they?
Well, yeah, I think that they can if the ambiguity only comes to light later. And I think that's the reason that the register found that this continuing jurisdiction was necessary and appropriate under correcting errors, and that you could reopen prior proceedings even after that rate period was closed. Because if the ambiguity only becomes clear as further rate periods go on.
But so in the settlement agreements that were previously reached, what did they decide about the rates to be paid for these BES gross proceeds percentages?
In some of the rate periods, the rate has crept up slightly from period to period, the percentage of revenue, but the language about gross proceeds and how it's defined has not changed.
But I'm just wondering, what number did they come up with? And did that number reflect including or not including the BES?
It reflected the gross proceeds definition as it has always been since the first CARP, after the first CARP. And so the only thing that.
Which means it didn't include the BES.
It was only BES, so these regulations only apply to revenues received by a BES for provision of its BES
Right.
The
I'm
only-
just wondering, like the issue before us
The
is
issue bef-
whether to include or not include certain
Sole
things
purpose,
within
right.
it. Right. And I'm just wondering if the number that they came up with included or did not include that.
Well, based on the plain language of the regulation, Music Choice's position is that it always included this limitation on
Right.
gross proceeds.
And was that reflected in the prior things that were reopened, the prior determinations?
It was never specifically discussed.
It wasn't discussed, but the number must have
Yes.
reflected a calculation, and that calculation reflected Music Choice's position?
Yes, because it's in the plain language of the regulation.
The royalty is
Well,
just,
Go ahead.
Is what you're saying is that there was a prior proceeding, this regulatory text was the same, and that was mainly about the number 10, 11, 12, now it's 14.5%, right?
Mhm.
And that's what you agreed on. And it's just that nobody had thought of this question. What do you do with a sole purpose versus a dual purpose channel? And that's the ambiguity that has arisen in the context of this dispute. So you reopened that proceeding. And in your telling, we have jurisdiction. Is it as simple as it was a reopening under 803C4? So this is a contested order of the board under 803C. You have jurisdiction. Is it any more complicated than that?
I certainly don't think it's more complicated than that, because that is the sole basis for jurisdiction that was cited. 803D, the appellate jurisdiction provision, says step back. C4 only allows the board to issue an amended determination to correct an error, right? So all that they could have done is issue an amended determination. In D, the appellate jurisdiction, it says any determination under 803C is appealable to this court, right? So it clearly, based on the only possible grounds of jurisdiction that the board could have exercised, because it has no other jurisdiction, that is clearly subject to appeal in this court.
Well, they might stand up and say they have some other authority, but can I ask you about the merits?
Yes.
Just
yes, Your Honor.
as a practical matter.
Yep.
And this is going to simplify somewhat. Your basic position is if Music Choice offers a channel and it only goes to BES customers, you pay the royalty on revenue received in connection with that channel.
Not exactly, Your Honor. What it has to do with is what technology is used. How does the transmission, the broadcast transmission
Okay,
get?
so the one more detail would be you use at least one ephemeral copy in transmitting that channel to your BES customers.
Right. There are some subscribers to Music Choice's BES for which the exact same transmission that goes to other types of services goes to the BES without any additional copies being made. It's only a performance. But there are some subscribers that Music Choice has to use a different technological system to get those broadcasts to the location that do require at least one additional copy to be made. And Music Choice pays the BES royalty on all of those.
So my understanding, the briefs and the record don't say much about the technology, but to my understanding, it was essentially a difference between channel 1 goes just to BES customers, and it has to, for whatever technical reason, you have to create at least one new ephemeral copy. Channel 2, you are also creating ephemeral copies. It's just that it ends up it serves two services, your PSS and the BES. And you think you don't pay any royalties for the revenue from BES customers on channel 2.
Almost.
Okay.
Almost. Okay. And the reason that you don't see a lot of these facts in the briefing is because what was presented to the board was purely a legal issue of like, how do you interpret these? Then whether the facts line up with that interpretation would be for the district court to sort out, right? But to answer your question, there are channels that go both to BES subscribers and to other types of service subscribers, right? And the ephemeral copies at issue are server copies. They're basically these copies of the recordings that sit on computer servers and that are drawn from to create these broadcasts, right? Those are the copies. So once a channel is created using those copies, they can go to BES subscribers and they can go to other types of subscribers, right? The same exact channel. But even within the BES subscribers, some of them get it directly in the exact same way so that no additional copies have to be made. Other BES subscribers get it through a different, more of an internet type system that requires the making of separate server copies that have to create those performances. So basically it's a subset even of BES subscribers. There are certainly a number of subscribers of the BES who Music Choice does pay royalties on. Otherwise, they wouldn't be paying any royalties. If they had a way of getting the performances to all of their BS subscribers without
Let's take one of the hypotheticals one of the ways you just described is you need to create new server copies in delivering the music.
Yes.
Okay. My understanding of what this case is about is if that channel only goes to BES customers, you pay royalties. But if you also send the same channel to some other service, you don't pay royalties on what your BES customers pay, right?
No, because even if only in instances where additional copies are made does Music Choice pay the BES royalties. Okay.
No, well, that's what you think the rule should be, right? The Sound Exchange thinks the rule should be even if you have a dual purpose copy, you ought to, let me just simplify this. This is how it appears to a judge who has read this opinion and doesn't know exactly how it works.
Yep.
You're saying that if you make $1 million from your BES subscribers for a channel, and that's only people you make money from for it, you will pay the royalty rate 100 in some subset of these situations. But in that exact situation where you otherwise would have paid, I think it's right now 145,000, you will pay zero on that $1 million. Other than a BES subscriber. Isn't that what this case is all about? Because if it's not, I have no clue what this case is about.
Yeah, I mean,
That's the point of your solely argument.
That is
Yeah,
it is not going solely to BES. It is going to two services, and so we don't pay any royalties on the BES.
but it's not whether the transmission is going to, because remember the odd thing about BES services is there is no public performance right. Okay, so the question of whether services are receiving performances should be irrelevant to the value of this license. It's
But
only,
that's not even how it works on your view, counsel. Your view is as long as you make one, if you have a BES only channel, you might need to make one ephemeral copy or you might need to make 1 million.
right.
It doesn't vary. Your royalty payment does not vary based on 1 copy or 1 million. It varies based on the payment your customer gives you because no one cares about how many ephemeral copies you make. They care about what value are you deriving from it.
Well, but that is driven by what's in the actual regulation. And I would just point out that sound exchanges and the board's interpretation would have the same effect as long as Music Choice changed so that all of its revenue came from payments in kind. It would, so
Can I just get an answer to Judge Garcia's question, which was, if you've made a copy, you've made your copy and you've used it for your PSS service, and then you use that same copy to send out to your BES customers, do you pay anything on the proceeds from those BES customers?
you do not, according to the terms of the regulation, because those are.
So this is what I'm trying to build up to.
Yeah.
Why does that make any sense, right? It would, just as this might not be the reality, but it would allow the result that you get $1 from a PSS customer and $1 billion from BES customers, and you'll pay whatever the royalty rate is on your PSS income and $0 on your BES income. And these terms are supposed to reflect, real world effect. And I want to know, if that seems to be the rule, why would someone agree to that?
It's not a question of agreeing to it. It's a question of what is in, what are you looking at the
So
statutory
separate from the
basis and
text.
regulatory?
I just want to understand as a
Yes.
practical matter why it's not a seemingly absurd result.
Absolutely, because there are certain types of services that Congress has decided are exempt from public performance royalties. Terrestrial radio is one of them. Business establishment services are another. So Congress, and when the law was changed in 1995 and 1998, and even recently in the Music Modernization Act, Congress still has not changed any of that. So there's already been this idea, and let's be clear, the value of a radio transmission to the consumer is the performance, okay? The rest of it, they don't care, as you said, how many ephemeral copies are made. So Congress has already said as a starting point, the record companies aren't entitled to a royalty for the performances. And by maintaining that, even when they created this ephemeral copy provision and this license, certainly it would be possible, for example, a BES could decide to stream all of its performances from CDs, not make any copies at all. Even if they don't happen to have dual use copies.
And then you wouldn't need a 112E license at all.
Correct.
Okay.
But it's clear here that because if a BES shouldn't have to decide to be all in or all out, there's no rational reason. If the record companies can get a little more money because for some of their customers, they prefer to use a different technological system where they have to make additional copies, then they pay a royalty. But there's no, in our view, what this regulation does is balance this admittedly odd situation where Congress had said they're not entitled to royalties for the performance, which everybody knows is where the actual value is. But if you want to make these server copies, you can get this license to do that. So this is a way of balancing, because reading it as if all fees and revenues, even where no additional copies are made, fall within this. That essentially gives the record companies a royalty payment for the performance where no copies were made.
Here's another, maybe this is a technical question, but it's actually about the regulatory text. It refers to derived from the use of a lot of words that I think mean ephemeral recordings. So derived from the use of ephemeral recordings. And whenever you describe your argument, you say derived from the making of ephemeral copies, because you want to say that whenever you make a copy for two purposes, it's not included. And is there a difference between the making of the copy and the using of it? Because you could imagine a world in which you're making an ephemeral copy, it's stored on the server, and then you're just calling on it on different times for your different services. And one reasonable view of that would be you made it at time one, now you're using it. And when the second time when you use it, it's for the sole purpose of facilitating a BES song performance. Is that how, what's your response to that?
Yes. Well, my response to that is, first of all, you have to look at when it's talking about use under 112, it says use under section 112. Section 112 only relates to the reproduction right, the making of a copy. There is no, in section 106 of the Copyright Act, it sets out specific individual exclusive rights. There is no, copyright owner doesn't get the right to use the copyrighted work in the broadest sense. There are these exclusive rights. And the only right that is granted under section 112, under the 112 license, is the right to make reproductions, to make copies. So that's why, and because—
For a particular use.
Yes, for a particular use, okay. But the way that Music Choices technology works in these situations is that the use is the same. It's the same transmission that goes to cable companies, and then it either winds up after Music Choice is done with its part of the process. It either goes to a commercial customer or a residential customer. So even with respect to the question of different use, it wouldn't make a difference in its application to Music Choice's situation. Because it's always using, even if you were going to say—
sort of going out, the channel is going out, and however you're making and using ephemeral copies, it's being done the same way for the P. It's simultaneous for both customers.
Exactly. There's no distinct copies at any time involved in the process. The only time that there's a difference is at the final performance. And that's why, trying to capture that into
You're calling performance the use?
No, the performance, the use is the use by Music Choice when they're transmitting. It's because the use is
transmitting, let's just make it simple, down your BES line or down your subscriber line?
There's only one line. And then at the cable company point, it then branches out to in particular subscribers. Some are business subscribers,
Okay,
some.
you must be in control of that branching process because that's how you're making your money is from those people on the receiving end of this music, correct?
We do get royalties from the cable company that are passed on based from the subscribers, yes.
Do you tell us, sorry, is the cable company some freestanding player that does what it wants? Or do you say, here's my list of BES customers, they get this music, here's my list of subscribers, they get this music?
It's actually the cable company that has the direct relationship with the business subscribers in those
They
instances.
may have a direct relationship. Do you have any control over it or any input into it?
No, I don't believe so. I don't believe.
So you have one customer and it's a cable company?
No, there are many cable companies, and then there are other business establishment subscribers that go through another process and those are the ones that we're paying the royalties on and why we have to set up different servers for that purpose. Okay. But again, the use here, the key thing I think to respond to your question is the use that's described here is use for the purpose of facilitating a transmission. So the use is not the transmission. It's the use of the copy to facilitate. It's before. What is captured in here, what is supposed to be captured in here are the uses before the actual, final performance.
What technically is happening? How are you using the ephemeral copy?
They're sitting on servers and they're then being used to generate streams of bits. And once those streams of bits are going through the pipes, the DC Circuit has a case, I'm a Pizza, that says those sorts of I'm a Pizza. Honestly,
I love that.
it's a great title. But it's a greater case because it makes very clear that once these digital files are being transmitted for the purpose of these performances, like as they're being transmitted through these pipes, just in bits and bytes, those are not copies actionable under the Copyright Act. You can't sue somebody. In that case, it had to do with jurisdiction. And the only conduct that was happening within the United States were allegedly infringing digital images being transmitted through the internet to get other places. And what the court found is because those files were not assembled and then viewed, there was no public display because for images, it's not public performance, but public display, because that all took place outside the United States. And only these, what they called ephemeral copies, it was a different use of the term than is used in the statute. Those types of ephemeral copies are not even actionable under the Copyright Act. So to say that that would be covered by the license, it couldn't be covered by the license because you don't need a license for those.
So, but you concede that you are using the ephemeral recordings in two streams to your individual listeners and to your business establishment customers. So it is a use of an ephemeral recording either way.
There is a use of an ephemeral recording. In some instances, it's being used to facilitate more than one transmission, one transmission that goes to multiple non-BES customers and BES customers. So it's not for the sole purpose of a BES transmission.
So let me ask you this, counsel, because when I look at the language that we're interpreting here, it's for the sole purpose of facilitating a transmission to the public of a performance of a sound recording. That is the definition of an ephemeral recording. Like the definition of ephemeral recording under 17 USC section 112 is blah, 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 but it's used solely for the transmitting of organization's own transmissions within its local service area. I think solely in this context seems to me just to be describing what an ephemeral recording is. It's used solely to facilitate transmission. Like you had to make this copy to facilitate transmission. And if that's what for the sole purpose means, they're just talking about ephemeral recordings. It seems to me that the best reading of this is that you have to pay anytime you're using an ephemeral recording. And it's not about whether it has a dual use or whatever use. You just have to pay whenever you're using it.
Well, respectfully, Your Honor, that leaves out the rest of that clause, okay? It doesn't just say for the sole purpose of facilitating a transmission. it says a transmission under the limitation on exclusive rights specified in 17 USC 114 D1C4.
Which I
So-
thought was the
Yes.
the provision that says you have to pay
Yes, but only for that's,
the
no,
ephemeral recording.
I'm sorry.
Yeah.
The 114 that they're citing here is the exemption that BESs have for the public performance right.
Right, but you have to pay the license for the ephemeral recording. That's what this is saying.
Well, it's saying only if it was used solely for the purposes of a BES transmission. That's
No,
what,
I think sole purpose goes to just, this is an ephemeral recording. It's the definition of an ephemeral recording. So if you use, for the use of an ephemeral recording, you pay. And this rest of it just says you would be exempt from performance licensing fees, but you still have to pay the ephemeral recording licensing fee. And so you should have to pay anytime you use the ephemeral recording.
well, respectfully, Your Honor, I just don't think that's what it says. The 114 is not the ephemeral recording. That's saying it's the BES service.
Under the limitation on exclusive rights specified
Right.
in there. So you wouldn't have to pay for the performance recording, but you would have to pay for the ephemeral recording.
But this regulation has nothing to do with whether or not Music Choice has to pay for the performance. And by the way, I would point out that neither the
Correct.
board.
So the only thing that is referencing is, we're not saying you have to pay for the performance recording. You have to pay for the ephemeral recording anytime you use it. So it's not about whether it has a dual use or a single use. If you use it, you pay.
Your Honor, I would say that, first of all, neither the board nor Satin even argued that it was that broad.
No, I
okay?
understand that. But I mean, if we get to the merits, it
Yeah.
seems like we have to look at this afresh in some sense. And it just seems to me that the most logical reading of this regulation is that this whole disputed language, it's not that it's modifying in kind, it's that this is describing ephemeral recordings. It is exactly the definition of an ephemeral recording under the statute. And so all this is saying is you pay when you use an ephemeral recording.
No.
That's the way I read it.
Your Honor, respectfully, that's not true. This is not the definition of ephemeral recording. There are all types of ephemeral recordings other than
Well, I'm
BES
just looking at
ephemerals.
17 USC section 112, and it uses the word solely, but just, it's only trying to describe that you're making these ephemeral recordings for the use of transmission. You use it to facilitate transmission. That's what solely means in this context. It's
Well-
not about the difference between dual uses of an ephemeral recording.
But
It's
that-
just what an ephemeral recording is.
But that is the purpose of saying solely for the transmission under the limits of a BES transmission, which is what 114 D1C4 means. It is not saying you have to pay you don't have to pay for the performance. That would have no logical relationship to how you calculate the royalty just for the ephemeral copies.
It's ephemeral recordings subject to the limitation on exclusive rights specified in 17-114 D1C4, which just says you don't pay for the performance. So you still have to pay for the ephemeral recordings.
But then what work is for the sole purpose doing in the regulation?
That's the definition of what an ephemeral recording is. It's made for the sole purpose of facilitating transmissions. And the word sole is in the definition of ephemeral recordings.
But that would already be captured in the citation to 112E then, if that were,
Derived from the use of copyrighted sound recordings during the license period pursuant to 112E for the sole purpose, which is ephemeral recordings. I mean, it's not obviously a great drafting job, but it just seems to me that the most logical reading of this is sole purpose is just the definition of ephemeral recordings, because sole purpose is in the definition of ephemeral recordings. And it's not about splitting up whether it has a dual purpose or sole purpose. It's just ephemeral recordings.
well, as I said, that would have the effect, reading it that way would have the effect of capturing all of the value of all of the performances, even where no additional, the very usage that's allowed by the license isn't being taken advantage of.
Wait,
The
so
making of
when you
copies.
make an ephemeral recording, it looks like you make it and it's good for 6 months, right?
In practice, those time periods are waived by the regulations and the agreements of the parties in the industry. People are not refreshing their server copies every 6
Okay,
months. So
but you use that ephemeral recording, I guess, once during the 6 months for each of these two streams, or how often do you use the ephemeral recordings? How
They,
does that work?
they essentially sit there indefinitely. I mean, there may be times
But
when
you're
they,
using the same one over and over.
Yes.
You're transmitting the same one
Yes.
over and over.
That's
So you would only, so right now, you would theoretically be paying it once for a dual purpose thing. And if you just read ephemeral recordings and this provision the way I do, you would just be paying it twice because you would use it once in this stream and once in that stream. And that's the way it would work.
it would all depend on whether for a particular subscriber, specific copies were made solely for that BES subscriber. For that solely for,
But take away your reading.
Yep.
Under my reading, which is that for the sole purpose of facilitating, it just means ephemeral recording. So basically you pay if you use an ephemeral recording. It's the same recording. How many times do you use it? You just use it twice when you're using it for both streams?
it's used, no new copies are made, but it's used every time a channel is transmitted to, it's a broadcast model. So there's one transmission that goes to tons of subscribers.
And what do you pay? Do you pay every time it's used or only, how do you pay for the ephemeral
We pay
recording
based on
license?
all of the revenue from subscribers going on, in perpetuity, that are relying on these server copies that are only
On the
made for the
ephemeral
BES.
recording?
Yeah.
So gross proceeds based on the ephemeral recording?
Correct. The
No
ones
matter
that
how
are,
many times you use it, it's just
right,
what
because
you're getting for it.
right, because you're paying based on the revenue. So
So under my reading of the statute then, if I think that this just means sole purpose equals using the ephemeral recordings, you would just pay gross proceeds based on your BES stream as well as your, I guess, private listener stream, whatever you want to call that.
it would be just the totality under that reading. It would capture, irrespective of how the ephemeral copies were used, or all gross revenue. It would essentially render all of this kind of beside the point, because
But it would capture it so long as you were using an ephemeral copy to transmit songs to BES customers.
right. But if you are not, I'm sorry.
Go ahead.
If you're not using any ephemeral copies, so if you went back to the system where you're playing it off of CDs, you wouldn't need the license, that you wouldn't be paying any royalties anyway,
So
right?
why don't they do
Agreed.
that?
I don't know. I know that earlier in the history of Music Choice, I think there was a time when they were in
Sound
their,
quality's probably not as good.
I don't think that's the case, but yeah, digital compression is not great over the internet necessarily.
Why are you doing worse music then?
Honestly, Your Honor, as far as the facts related to this, why the Music Choice makes, I'm sure that there are benefits to doing it the way that they do it, right? It's cost benefit analysis.
So Judge Pan was asking why it's unreasonable if, I think we all agree that if you have a BES channel that doesn't use ephemeral copies at all, that you don't pay royalties. And what Judge Pan, I think, was suggesting was all that would happen under her reading is that you pay the royalty based on the total BES revenue for a channel that you do use an ephemeral copy in, one or more, right? Why is that unreasonable?
I believe it's unreasonable because if that was what the regulation was trying to accomplish, it would have ended just with gross proceeds are all, like all of this other, like, so for example, received from any source during or after the license period, you wouldn't need any of these qualifiers on the revenue. You would just say all fees and payments, including those made in kind, derived from the use of any ephemeral recording.
That is what it says, because before that, they don't define ephemeral recording.
But then it goes on and it says used for the sole purpose of a BES transmit, of facilitating a transmission to a BES.
Right, that's the definition of ephemeral recording.
Don't you want two soles in here? You want the word sole, as Judge Pan's saying, that's just describing the purpose of facilitating a transmission. But you want another sole further down that says, transmission to the public of performance of a sound recording solely under limitation. We would say solely to a BES customer. You want actually a solely. You want an adverb.
I don't believe so, Your Honor. I think the sole, I
sole's
don't
going
think you
off
have
like-
to repeat. I'm sorry.
So it's just going a long way down the sentence and you want that sole up there to do two things, be an adjective and an adverb.
But there's no intervening switch. There's nothing linguistically like there is with the including those made in kind reference, which does operate as an independent thought. There's nothing in the rest of that sentence that would require another solely.
It does, because you wanted to describe both the purpose of facilitating a transmission, the
But
federal
wh-
definition, and that transmission has to be solely for BES customers. Is that right?
No, I don't think you need another solely because that's one law. Admittedly, it's an awfully long sentence, but that's not unusual in an agency regulation. There's nothing that switches
Your
the
reading
register.
is solely. It has to go solely to a BES customer. The transmission, we only pay if it goes solely to BES.
Solely to facilitating a transmission to the public of a sound recording under the BES statute. That's all one clause.
I'm just saying, you want the sole to operate on where this ends up.
On the entire rest of that sentence,
You want
yes.
it to go where this ends up.
I-
At a BES.
It limits the entire remainder of the sentence.
Okay. Okay. All right.
But if the sole purpose is facilitating a transmission, that just means it's an ephemeral recording. So the use of this definition of ephemeral recording under the limitation of BES means if you use the ephemeral recording for a BES transmission, you pay.
In the way authorized by law.
Yes.
I'm not sure. It's solely for the purpose of a BES, of a transmission to a BES. That's what
That's what Judge Millett is saying. You want to add an additional meaning of solely, because I read
wanna add
solely just to
solely
be,
and not
the
sole.
use of it is for an ephemeral recording. It's used to facilitate the transmission. That's the sole purpose of it. But you're trying to say, and it has to go solely to a BES.
I
like two
believe that's what the
soles.
sentence says because it's one continuous sentence.
But
I don't
not
believe-
if sole means my meaning of it.
Sole
It-
modifies purpose here. That's just grammatical. Sole
Yeah.
modifies purpose.
Sure, but the purpose, in
Whether the
describing what the purpose is,
facilitating-
sorry.
Just trying to get it out. So you can understand, there's two things that could be. The sole purpose could be to facilitate a transmission to the public of a performance, definition of ephemeral recording. Or you want it to be sole both as to the purpose of facilitating a transmission to the public, and that transmission is solely for BES performance.
Yes.
Which, by the way, is solely, not sole.
I think that because of the construction of the sentence, I just don't think you need that second solely.
Can I haul you, probably against your will, back to jurisdiction?
Sure.
So to start, you made a point that somehow there is a determination, even when there's a settlement in royalty proceedings. I don't see that in 803. They just have to, if it's royalty, notify people, have your period of voluntary negotiation, and the same for distribution. And they only do anything, the board only does anything more under 4 and 5. Where is this requirement that if it's a voluntarily negotiated settlement involving royalty proceedings, then there will still be a determination by the board? Is that in the statute?
I don't have the site off the top of my head, Your Honor. I do know, I believe it's,
this distinction in your briefs at all.
well, I think the reason for that is if you were to look at the actual, in each of these proceedings, if you were to look on the docket of these proceedings that were reopened, after the settlements, there was a final determination issued by the Copyright Royalty Board. This is not something I think that Sound Exchange or the board would dispute. If you look, there was in the Federal Register, there's a final determination and the judges recite. First, they publish, there's a process for these.
Sorry, are you saying that you're not aware of a statutory provision that says even after a voluntary settlement?
No, I believe there
royalty
is.
Proceeding, okay.
I believe there is. I
Maybe
just,
you can give me that on rebuttal then.
Okay. But I would also point out that couldn't possibly be disputed that in both of these proceedings and in all of the proceedings that have ever been settled, what the judges do is
Both royalty and,
not distribution. I'm just talking about excellent distinction. But for rate making proceedings, the process is, and I'm sure it's required by statute, is that the judges publish the settlement terms, and there's a period of where interested parties can comment. Okay. And then after the review for reasonableness that I discussed, they then issue a final determination where they adopt the terms and implement those into the federal rate. And both of the proceedings that were reopened,
they
were
just adopting and put it into the Federal Register.
in a final, but what they issue and what they
Do they
publish.
decide anything?
Well, they decide that the terms are reasonable. Yeah.
And they have authority to change them.
Yes.
And then the other thing that I'm a little confused about is what was reopened in here were two settlements. Was everyone who was a party to that settlement, those two settlements, everyone notified of this proceeding?
Yes, Your Honor. And technically what was reopened were not settlements. What was reopened were the prior proceedings before the Copyright Royalty Board. Okay.
I understand, but they're changing. If they're going to change, as we can see, had someone said, when you all agreed into this agreement here, did you know, copyright holders, that you were giving up this thing, given this, as you read it, definition of gross proceedings, I would have thought there would have been a lot of very unhappy copyright holders in the proceeding.
Well, first of all, let me answer your question directly. Yes, both when Sound Exchange filed its motions to reopen the proceedings and every other filing that either party made during that process, they were all served on all of the participants to the original rate proceedings. So that notice did go out. They all did have notice of it. Okay. Now, with respect to copyright owners, their interests are represented by Sound Exchange. So
every single copyright owner.
I don't want to speak to Sound Exchange, but
that was a participant.
They were the only ones who participated in the prior proceedings on behalf of the copyright owners. So they would be the only ones who would have standing to participate.
When they have the notice and comment period, do you typically not get comments from individual copy holders? They just trust Sound Exchange to handle that? For
settlements, you're talking about when a settlement?
For the whole process, I guess there are a lot of different types of processes here, and some require notice and comment. And during the notice and comment period, I'm just wondering if you typically do get input from individual copyright owners, or do they just trust Sound Exchange to represent them? With respect to final determinations, I don't believe there is a notice and comment period. If you are a participant, you can object or you can appeal. Once it's final, the final determination is made, then participants who are aggrieved can appeal to this court. But there's no general notice to the public for comment. So for a usual determination, I was under the impression, maybe I misread something, that I thought when you're just doing a determination, not an amendment, just a determination. Yep. Is there like a notice and comment period?
I think that the law is that you have to be, people can, I believe when there's a settlement, a proposed settlement that the judge are going to adopt, at that point, there's a publication and there's an opportunity for comment. But the Copyright Royalty Board has held, I believe, that unless you were a participant, the objections really don't count for a whole lot. But with the final determination, it
calls for petitions to participate, I guess.
Correct. Yeah. You have to be in, and you have to be in for the whole thing in order to maintain the ability to appeal or have some sorts of objections.
So I'm just trying to figure out what might have been missing from the process here if it were inadequate. Because if they're trying to amend a determination and we think an amendment has to deal to technical things, and this went beyond that, what normally would have had to have happened? Like if it's not technical and it's not an amendment, it's a determination, what would have had to have happened here to make a new determination as opposed to reopening an old determination?
Yeah, I believe as long as all of the people who had filed notices and had actually participated all the way through had notice, that's it. There's no general public right to participate in these proceedings if you
Okay.
don't file a notice.
So if Judge Walton had certified this over to the Copyright Royalty Board, and instead of you petitioning to reopen, you just said, we would like a determination on this issue, what would have happened?
Oh, they'd have no jurisdiction to do that. They can only institute a proceeding on the rulemaking side. There are several different statutory licenses.
Mhm.
Each one comes up for renewal every 5 years.
And that's the only way they come up
That is,
for an initial determination. It has-
there's one other way.
Okay.
Now that I think about it, if there's a new type of service that falls within a statutory category, then Sound Exchange or the service can then ask the board to institute a new proceeding. But it's only, that would be to set different rates and terms for a statutory license that there's never been a service like
I
that.
see, I see. So the only game in town is an amendment to a prior determination based on the facts we have here. It's the only way you can sort of sua sponte do something that's not on the 5-year license clock.
That is correct, Your Honor. The
Okay.
board does not have jurisdiction to just institute proceedings because it wants to, or even because parties ask them to. It has to be linked to the statute and particularly these licenses.
Interesting.
So if C4 is the basis for them acting, for acting under C.
Correct.
How much money is at stake in your differing interpretations of that regulation?
In the actual royalty, I'm sure it's tens of millions of dollars.
Wow. Is that a technical or clerical correction?
Well, I think it's a technical and the argument from the register as to
No, I know, I understand the register's
Yeah.
argument here.
I-
Technical or clerical is a term that's used in statutes elsewhere, and it means, oops, misspelled word. It doesn't mean a decision, a hotly contested decision between copyright holders and users of their music that will determine where tens of millions of dollars go or don't go. And what possible dictionary definition can you give me that would fall within that?
Well, Your Honor, I would say
It
first,
seems like it's unsettling a settlement agreement.
I don't think whether the error is clerical or technical.
Not clerical.
Well,
What's technical about it?
Well, I think that the argument would have to be that there's an ambiguity that by implementing a regulation that was ambiguous, that amounted to either a clerical or a technical error.
Right. We would have to hold that this substantial dispute on the meaning of determining what royalties are to be paid, right? This is $10 million and tens of millions of dollars in royalties that you would or would not have to pay, correct?
Yes, I would say. Yeah.
And if they normally, I mean, they can do technical errors, clerical errors, or modified terms, but not the rates of royalties
Correct.
payments. Isn't this directly resolving an issue about the rate of royalty payments?
But it's not modifying. It's saying what the regulation was supposed to mean. And
Is
that's,
that a technical or clerical? That's not clerical. I don't see how that's technical in the way that that is used in other statutes or court rules. Do you have any definition where something that is a substantive dispute about royalties that are owed or not under this statute would qualify as technical?
whether the board introduced an ambiguity into the regulations or
No,
allowed
wait,
an.
no, they didn't
Right.
introduce an ambiguity. The parties here chose to carry this regulation with all its baggage or not into a settlement agreement. And we're going to, I'm just asking you for any natural meaning of, and it's clerical or technical, those errors. That's a category, and that's a category that's different than modifying the terms.
Your Honor,
Yes.
it could only be, and the reason that my hesitance, I'm not trying to be difficult. In candor to the court, Music Choice made the argument to the district court that there was no jurisdiction for the Copyright Royalty Board to issue these types of
Yeah, this
regulatory.
doesn't fall within C4 at all, right? I'm agreeing with you.
I understand, but we lost that and now we're 5 years
But
later.
you lost it before
Well, that-
them, not
Yep.
before us.
Understood, Your Honor. Understood, Your Honor.
Sorry, can you clarify one thing? You
Yes.
never argued that 803C4's technical or clerical authority does not encompass the ability to clarify regulations, right? You made
We
other
argued,
objections
we,
to 803C4.
we argued that before Judge Walton. We did not argue that before the Copyright Royalty Board because there was the register's ruling, which was binding on the Copyright Royalty Board that came out the other way.
Judge Walton, did you argue that register is wrong and they have no authority to clarify any regulation under 803C4?
My recollection is we didn't specifically say the register was wrong. We just went straight to C4 and said this is not a technical correction. We made other arguments as to why it wasn't appropriate for a referral, but we did argue that.
That it's not a technical correction because technical correction in the statute means what in your view?
Right.
It means what in your view?
Well, in that technical correction or a clerical, we didn't really say what it would mean, but we said that just resolving an ambiguity where parties have differing views of what the regulation means was not a technical correction. Admittedly, we didn't spend a lot of time on it in the brief, but we certainly made the argument.
So it seems to me then the upshot is the Copyright Royalty Board attempted to, well, purported to reopen a determination to resolve a question. But under the provision for reopening, C4, it was only allowed to do technical, make technical corrections. And so it exceeded its authority to do that. And so if that's what we think, then we have jurisdiction because they purported to amend.
Yes.
That's what's before us. But we vacate it because it wasn't technical. And I don't even think a remand is appropriate, is it? Just if we think there's no way you can do this under C4 and C4 is the only game in town, then it seems like there's not even a point to remanding. We just vacate. And then you go back to Judge Walton and say, you resolve this. Is that what happens?
Your Honors, I agree with you. I agree with you. If Your Honors find that the CRB didn't have jurisdiction under the first part of C4, then you would have to vacate.
Under any part of C4, honestly.
Well, yes, because I think the second part is a non-starter, like amending because of unforeseen future occurrences that frustrate. If you look at the legislative history of that provision, the example they gave was if Sound Exchange, if the collective that had been designated to collect royalties went out of business in the middle of a rate period, could the Copyright Royalty Board, change the collective? Like actually that would be a substantive amendment, changing what the regulation means, right? And they need to be able to do that in exceptional
So why
cases.
didn't you argue this in your brief? If you just agreed that it doesn't go to our jurisdiction, it actually sounds like a straightforward ground on which you would argue this exceeded the board's authority under 803C4. And the normal response we would give was, well, you didn't exhaust that before the agency and you forfeited it on appeal. So why is that not the way to think about it?
Well, Your Honor, for a number of reasons. Number one, there is the register's ruling, and I do think that Music Choice just didn't take a position because frankly, to be again candid, we're now 5 years down the road. Music Choice is a tiny company in Horsham, Pennsylvania. We didn't want any of this happen to begin with, but now that we've gone through it, we wanted to get a resolution. So we didn't, and there is an argument. I mean, the register's decision, you can, I would understand if the court disagrees with it, but it's not like it wasn't based on anything. It was an interpretation of what the register thought. Now, whether under Skidmore, the court finds that persuasive or not, it's certainly the Register of Copyrights talking about a technical provision of the Copyright Act.
So I appreciate that. And just one last question about the practical. We have all these strange jurisdictional questions, and I'm not sure how this connects technically, but in a practical way, we're just reviewing an interlocutory order. There's an ongoing district court proceeding, and it's very odd that we're here. And I think the practical way of asking the question is, you chose to appeal now. You also could have just gone back to the district court. I suppose there would have been a judgment entered against you, and you would have appealed to us then. What is lost if you have to do the latter thing?
Well, a couple of things. That process would take, it's not just that we go back there and the case is over, right? The case never got started. So at that point, assuming, and, Judge Walton indicated he felt like our deference should be paid to this. We disagree with that for a number of reasons. But he already indicated he was inclined to go with whatever the board said. But then there are other disputes in the case, and damages and everything else. So you're talking about another.
Those are there either. You got to deal with those regardless.
Well, not if we prevailed on this appeal. Well, I mean, it would be likely to,
Well, if you're listening to the first argument,
Yeah.
you're asking for a ruling to guide further proceedings on remand in the district court. It's just a little bit odd.
yeah, I mean, I think the bottom line is that this decision, if it stands as a determination, an amended determination, the Copyright Royalty Board also has independent legal significance other than in connection with our district court litigation, okay? Because in the next BES proceeding, which is going to start in 2 years, this court has held that to the extent a court wants to change regulations, they have to support that. There has to be more of a showing than if they're writing on a blank slate. Like what is motivating the change, especially if the parties have relied on that for a number of years, right? So having this final determination about the meaning of this regulation will change.
Well, it's going to change either way. Right? Someone's going to be unhappy. Right? You're going to have a new interpretation. And quite frankly, the district court could have just asked for maybe, I guess we'll hear what the government says, an amicus brief from, I don't know whether it's the Register or the Librarian of Congress or the Royalty Board, but somebody on what this means. He can read what they did. But the question is whether if there's going to be a decision, there's going to be a decision. But now is not the time to, I should have thought you would have wanted to go back and make your legal arguments in the district court. But this is jurisdictionally baseless. Which the government seems to kind of.
Well, I mean,
maybe agree.
I mean, Music Choice was trying to get the key issue resolved. And the quickest way, having taken this detour, was this. If it was an amended determination, which is the only thing it could have been, if they had jurisdiction to do what they do, it could only be a determination and it would be subject to appeal in this court. So.
Okay. Questions? All right, thank you.
Thank you, Your Honor.
From the government now.
Good morning, Your Honors. May it please the court, Amanda Mundell on behalf of the government. I want to pick up right where the court left off with the colloquy with my friend on the other side. And this somewhat extraordinary claim that an agency simply has no authority to offer a non-binding interpretation of its own regulations. And instead, there needs to be some sort of express statutory grant of authority to do that. That is quite extraordinary. Agencies have always been understood to possess a measure of authority to issue, again, non-binding interpretive guidance, which is exactly what the copyright royalty judges did here. So we see 803.
What's the source of that authority?
I'm sorry, Your Honor?
What is the source of that authority?
It's inherent authority. And the district court actually recognized that in its opinion, referring the matter to the
You've
board.
got an agency here where Congress has been very, very specific about what their role is and is not. Make determinations if people don't work it out themselves. That's it. They're the only authority even to make regulations are all procedural ones for conducting their determinations. So anything that they decide about how they interpret some term or something has got to be done either through a determination in a contested dispute or adopted by the parties in a settlement agreement. There's just no other room.
Your Honor, respectfully, I disagree with that. Now, if the board were taking some sort of regulatory action, issuing a regulation, making a determination, things to that effect, of course, we agree there'd have to be some sort of statutory grant of authority unless some other independent basis gave the board that authority. But that's not what the board did here.
What is your best case for this inherent authority to provide opinions?
Well, Your Honor, I don't think there really is a case that has grappled with this background principle.
Well, you were shocked that we hadn't recognized this inherent authority, but there's no case recognizing it.
Your Honor, I think cases like Auer and Kaiser, of course, recognize an agency's authority to interpret its own regulations. There's other cases that are
the board's regulation. This was the registers. regulation. She's the one that put all this, she or he, I forget it was, put all this language in to this gross proceeds definition.
I think the librarian might have introduced that language,
Okay,
and this was
librarian,
all.
sorry if I've got- it's a weird procedure. Okay.
There are a number of
The
players.
Librarian of Congress is or is not even in the executive branch. That's a whole other thing we don't want to go to today. It's been litigated in other contexts. And so does the Librarian of Congress have the inherent authority to provide
An interpretation, Your
of
Honor?
regulation to the district court?
Well, I don't think the librarian's the one providing this interpretation here. And in fact, the librarian added that language in, part and parcel of the predecessor agency's regulation to the board. And so really what we have to think about is this regulation originated with the CARP, which was the predecessor agency. And now the board, which has inherited all of the CARP's authority, is issuing a ruling on regulatory interpretation. And the court asked me for a case about this inherent authority. I don't have a specific case that grapples with this principle. There are cases that get at this, though, in other contexts. I could point the court to Barr versus Mateo, which is 360 U.S. 564. And that doesn't deal with an agency. It dealt with Bill Barr's inherent authority to issue a press release on matters connected with his duties when he was an acting director.
That seems a lot more obvious than what happened in this case.
Well,
That an
actually,
attorney general can issue a press release is very different from what happened in this case.
I don't think it's any less obvious than
I'm just
here.
very surprised that you would get up and start with there's some kind of inherent authority to do this when it seems clear that what the board thought it was doing was reopening a determination. It reopened a determination and was trying to amend a determination. So why aren't you just relying on what the board actually thought it was doing?
Well, Your Honor, and I think some of the colloquy pointed this out. The board didn't actually say that it was proceeding under 803C4. It referenced the registrar's opinion that the board has authority to issue rulings on regulatory interpretation
Which
under
was relying on
803C4.
C4, like that note 6.
That's true, but
Ultimately is relying on C4.
I think 803C4's language matters
Did
here.
the register disclaim inherent authority at that time and say you got to go under C4?
I'm sorry, Your Honor, could you say
Did
that
the
again?
register in that decision disclaim inherent authority and say instead the board can only act under 803C4?
I don't think so, Your Honor. I have that decision with me. I don't see that express disclaimer. And in fact, the register even didn't bother to grapple with other possible sources of authority like the APA. So it was simply focused on if you're going to issue an amendment that clarifies a regulation, you can do it under 803C4.
To build on these questions, right? Normally, when there's a question about the source of an agency's authority, we expect the agency to identify that authority, and we apply the Chenery rule to what authority. And regardless of how you read note 3 and note 6, which think like, if that's all we have, it seems to tilt towards they thought they were doing 803C4. I don't think there's anywhere that they say something like we are relying on our inherent authority to respond to give an advisory opinion under the doctrine of primary jurisdiction, right?
And of course, it's not surprising that the judges didn't say that because neither party suggested that the judges couldn't respond to a district court question
I
like
think
this.
that's right. So if you think about it in a Chenery way, the only authority anyone ever mentioned was 803C4. We've got some footnotes that gesture at 803C4, and the natural conclusion would be that's the only authority the board thought it was invoking.
And again, Your Honor, I think that even if the board thought that 803C4 allowed it to reopen proceedings, the question is, what did it do once it reopened those proceedings? All it did was issue an advisory opinion. It didn't
But the
make an
point is, if it
amendment.
had this inherent authority, why wouldn't it have just said so instead of gesturing at C4? Since it's as obvious as you think it is, why didn't the board think so?
Your Honor, I don't know if the board thought it was, obvious or not.
Presumably
It's
they
not in
wouldn't
the
have had to
decision.
gesture at C4 if they had obviously this inherent authority to do what you say that they could do.
Respectfully, Your Honor, I think this is the sort of conduct that when a district court asks an agency for an answer, what is the agency supposed to do? The agency gives the court an answer. And it's not the kind of thing that,
That's not really the issue. The issue is it gave an answer, but it proceeded under C4.
and again, Your Honor, I think
It didn't say, I have an inherent authority to answer the district court, and here's my advisory opinion. It said it went to the trouble of reopening 2 prior determinations and presumably or purportedly amending them.
And I have a couple of responses to that, Your Honor. I just want to pick up on the reopening aspect because it's come up a couple of times. Just simply as a ministerial matter, there had to be some place on the docket to answer this question. That's why the
Not
board.
according to you. According to you, they have inherent authority just to answer the question. They didn't need to go to the docket at all, according to you.
My understanding is that in order to issue that ruling in some way, it has to do it on a docket. That's my
Why
understanding.
would they have to do that if they have inherent authority to issue advisory opinions?
Your Honor, I think there might have been a manner where the board could have answered this question in a different way. Perhaps the parties could have asked for the board or the librarian to offer a statement of interest in district court. But the way that this all came about was that Sound Exchange moved to reopen the proceedings. There was an opposition to reopen 1 versus 3. And at the end of the day, the board determined that it would reopen the proceedings solely for the limited purpose of answering the district court's question, not to amend any regulation or modify the text of a regulation, which of
This
course
doesn't fall under, what they did does not qualify under C4.
I don't think so, Your Honor.
They're not allowed to do this under C4.
Well, 803C4 just isn't relevant to what
They didn't
happened.
modify, they didn't correct an error.
I would say that 803C4 is just not,
I'd like to know
it's
whether the
ill-suited and
government-
it's not relevant to what they did.
I would like to know whether the government thinks that what they did here does fall under C4 or any part of C.
No, I don't think so, Your Honor, because there's no amendment and no modification. Nothing
So
changed.
you're disavowing the registrar's memorandum opinion that says that they can do this as a technical clarification. So you agree that that is not permissible.
No, Your Honor, and I want to be specific about what the question here is. There may be circumstances where the board uses 803C4 to issue a technical amendment. There may be times when in issuing that technical amendment, the board is construing a regulation to do so. It just so happens that here, the board's answer to the district court question has nothing to do with an amendment. It doesn't change the text of the regulation. It doesn't add a word or take anything away.
Ms. Mundell, the board thought it was amending its regulation. It's gesturing at C4 and it's got authority that says it can do this registrar's memorandum opinion that says that it is a technical amendment to clarify an ambiguity. You're coming in and sort of saying, no, that's not what they were trying to do. But the record shows that they thought that they were reopening and amending, which they thought they had authority to do based on this memorandum opinion, which is cited in JA 115 note 6. And so I'm asking you, if that's what they thought they were doing, are you agreeing that they could not do that and that this registrar's memorandum opinion is incorrect, false, cannot be relied upon?
We haven't taken a position on whether the registrar's opinion is false or unreliable. There may be
I
circumstances.
think you just have by answering Judge Millett's question and saying that C4 doesn't allow them to do that. Because that's exactly what that memorandum.
Your Honor, I'm talking about this case specifically. There may be other cases where that registrar's opinion actually makes a lot of sense for what the board is trying to do. And here, even though the board gestures to 803C4, I think this court still has to take a hard look on what the board actually issued. And here, the board didn't issue an amendment. It didn't issue a modification.
Right, so
That's not what the registrar's ruling says you can do. It says you can clarify. Give your position on what an existing regulation means. Of course, it didn't give an amendment. It issued what it calls a ruling on regulatory interpretation. It published it in the Federal Register. Isn't that exactly what the guidance, what the registrar's ruling envisions you would do in this situation?
Your Honor, I think the registrar's ruling envisions some sort of technical or clerical correction. I would have to go back to that particular instance because it entailed a provision about whether an exclusion included or didn't include certain things, and the regulatory text has since changed. So it's very possible that in response to that registrar's opinion, all of that work then resulted in some sort of change to the regulation that, of course, is different here. I'm not steeped in that instance, so I don't want to express a clear view on that. But I think
It
even
sounds like, this is why the Department of Justice represents agencies to express the views of the United States. And so looked at what happened here and have concluded that it is not, at least in this case, as it's arisen in this context and what they decided, there is no authority under statutory authority under subsection C to have made the decision they made here. And so you are offering another legal source of authority for their actions. Is that how I should understand what you're saying in this case?
I think correct, Your Honor. I just want to make sure I'm clear. 803C4, the agency didn't need to invoke 803C4 to accomplish what it did here, which is just issue a
It's a
non-binary
very different
response.
response. Mine is that I thought you had answered me directly. What they did here does not qualify under C4.
Yes, I think that's correct.
And then when you talk about the inherent authority, I think and this is another thing that's just very unusual, put aside that they didn't invoke it. There may be a good reason Congress really challenged what they're doing, because usually when an agency, they have a power to promulgate substantive regulations, freestanding, just to administer their program. Here, they only have authority to promulgate procedural regulations. And then as it turns out, they make decisions that then get labeled regulations in the course of, they could do that in the course of a determination, a contested determination. Or parties would say, I guess it's originated in this gross proceedings thing, originated in a disputed such case, 2002, if I have that right. Anyhow, you've got a regulation. They go, well, we're going to put that into our settlement agreement. Are you aware of any case where an agency has the inherent authority to interpret a substantive dispute in a settlement agreement? Because, the consequence of that is be very unsettling to a settlement agreement, one side or the other. And isn't that why this becomes very complicated?
I'm not aware of a case off the top of my head, Your Honor, or something analogous, but I actually don't think that the settlement overlay is relevant to this dispute because the regulation arose not because of negotiated language between parties, but because the predecessor agency, the CARP, needed to craft a regulation and the librarian added some language to it. So it's not as if—
Yes, but they only reopened 2 of the 3 proceedings, and that did not include the original one. This was adopted in a contested proceeding. They reopened 2 proceedings that were not formal determinations under the statute. They were just settlement, negotiated resolutions of royalty rates, at which point parties chose to incorporate that pre-existing regulatory language. And it seems to me quite a different thing for an agency to step in, reopen an approved settlement agreement, and say what the meaning of terms in that settlement agreement mean. If you say they're just clarifying, to clarify what a substantive term, this is the rate they have to pay in a settlement agreement is.
And I take the court's point that if that was what was going on here, reopening a settlement agreement, clarifying terms in a settlement agreement, that might look a little different from what we typically see agencies do. I'm not exactly sure that that's what's going on here. I agree with my friend on the other side that the board's not really reopening an agreement. It's reopening a proceeding that resulted in a determination that flowed from a settled understanding between the parties of what a percentage rate ought to be. And it's true that, of course, referenced and incorporated the regulation, but I think the board here was interpreting a regulation, not really trying to interpret terms in a settlement agreement, even though they may have been
We have said
referenced.
that when the board adopts a settlement agreement, that is not a subsection C determination. They want to say it's different for distributions and royalties. We can debate that, but it's not a subsection C. So they're outside their subsection C bailiwick altogether.
And that might be true. I confess I don't know if that's right. I'd have to think about that a little more and look a little more closely at the text. But I think the upshot of this, Your Honor, is that even if the court thinks that there was, that the board couldn't, reopen a proceeding to clarify a term in a settlement agreement, I think that only underscores why what the board here did is just non-binding guidance, that the district court can take from it what it wants, that this proceeding actually belongs in district court, where the district court will make a final determination as the meaning of this regulatory language. And then, the party who is unhappy with that result on final judgment can appeal to this court or even seek a 1292B and move things along a little more closely. So I think no matter how you slice it, whether the court, doesn't think this is an inherent
Are you
authority
saying they
thing,
can
but
bring this up on 1292B when our jurisdiction is limited to proceedings under C?
no, I'm talking about appellate jurisdiction from a district court determination.
Okay.
And I think this underscores why this court lacks jurisdiction in the first instance to review the challenge here.
You have, go ahead. I just had one other question. How does primary jurisdiction still work in a Kaiser Loper Bright world? Does the government have a view on that?
We haven't taken a position on that in this case.
Have you taken it anywhere?
I don't know, Your Honor. I don't want to speak for other matters that our office is handling that may or may not have taken that position. I don't see the parties really disagreeing that the district court could refer a matter to the board for ruling on regulatory interpretation. I think the parties maybe just disagree on what the impact of that referral was in this case. So that's why we haven't taken a position on the primary jurisdiction question.
Just one clarifying question. Going back to the discussion earlier, page 21 of your brief says the judges have continuing jurisdiction to correct technical errors in the board's regulations, including clarify their scope, citing this register determination, but that was not the authority they exercised here. Is that the same or different than what you're saying today?
I think that's the same, Your Honor. I think, we're not trying to disclaim what the register has said in that 2015 opinion and whether the judges have authority under 803C4 to issue technical corrections and to, clarify the scope in connection with that opinion. That's just not really what they did here. There's no change or modification to the regulatory text. Instead, I think this court could consider what the board did akin to, submitting an amicus brief. There's just no final action. There's no impact on the parties. The district court gets to decide how much weight to give this at the end of the day when it goes back to district court. I know we've been talking a lot about jurisdiction. I was hoping I might have a little bit of time to respond to some of the other statements that have been made earlier, although I see that my time has expired.
Before you do that, I wonder if you could comment. We have a case, Johnson versus Copyright Royalty Board from 2020. And in that case, we rejected, quote, vacillating gestures to uninvoked authority. And we vacated the copyright judge's action. And we said, and this is a quote, the board has considerable freedom to determine its own procedures, but that flexibility must be exercised within the lines drawn by the authorizing statute. Congress's decision to limit rehearing to exceptional cases and to confine other post hoc amendments to cases involving technical or clerical errors would be a nullity if the board also had plenary authority to revise its determinations whenever it thought appropriate. How does that fit in with you coming in and saying that the court has inherent authority to do what I think this case says it can't do?
Well, Your Honor, we disagree that the board is revising anything. I think that's the big distinction between Johnson and this. There's simply no change. And in fact, Music Choice doesn't identify a change. I think it's pretty telling that at the end of the day, Music Choice is still going to have to go before the district court, just like Sound Exchange, and hash out whether the board's interpretation is right or wrong. There's actually nothing that happens as a result of this interpretation.
Authority to do this if it's not within the context of the procedures that are permitted under C4.
Your Honor, I don't think there's, I don't
stay within the statutory lines.
I think, again, and I apologize, guys, I think it's probably an area of disagreement between the two of us, but I think that case is talking about revisions that are made by the board. There's no revision by the board here. So there's no inconsistency between that case and what we're saying here, which is that the board doesn't need statutory authority to just answer the district court's question and share its views on what the regulation means. And I think the APA sort of acknowledges that that's permissible.
The board is not allowed to do that, that it actually needs to act in accordance with its statutory limits. You still think that this is not the kind of thing that we can review?
Yes, Your Honor. And I would just love to provide a brief answer as to why that is the case. If this court thinks that the board had to proceed under 803C4 and did proceed under 803C4, I think you still have to look at what the board did. Did it really issue a determination? And of course, this ruling on regulatory interpretation doesn't have any of the hallmarks of a determination or a determination made in a proceeding that would be described under 803C. And that's why this court wouldn't have jurisdiction anyway under D to hear this dispute on direct review. That doesn't deprive Music Choice of this court's jurisdiction down the line.
Is that a jurisdictional question? Because it seems to me like we get cases where people say they were purporting to make a determination, but they didn't follow the procedures, or they're purporting to make a determination, but they weren't allowed to do it this way. That doesn't become jurisdictional if we agree that they weren't allowed to do it that way. That makes it not a determination, and therefore we have no appellate jurisdiction.
I see the inquiry a little bit differently. I think even if the court thinks that the board, was trying to exercise its authority under 803C4 to issue a technical amendment, I think this court would still then need to ask itself, is the thing they issued actually the reviewable determination that the statute provides exclusive jurisdiction for this court to exercise?
Can you think of a precedent that says that that's the way this works? Because, we get lots of challenges to determinations or rulings or agency actions. And if we agree, you could always try to frame it like, so it wasn't a determination at all. Therefore, you have no jurisdiction. Like, I just don't understand how that works.
I think unfortunately that might just be, part and parcel of the statute. The statute makes pretty clear that this court has jurisdiction to review, in the first instance, final determinations by the board. And so the court would have
Do
to.
that in IPG.
I'm sorry, Your Honor?
In IPG, we said that something doesn't count as a determination for
Yes,
purposes of our jurisdiction unless it has the statutory pieces of a determination. Because
Yes.
jurisdiction turns on it being an 803C determination.
yes. So I think that's, that the court has engaged in this analysis before.
Sorry. I know you just want, do you have any more at this point questions right now?
I think, well, I'd love to hear your main
You said
points on the
some other- yeah,
merits.
you had a-
So turning then to the merits, I think there's a few places to start, but I think, music choice is ultimate framing here, which is that it shouldn't have to pay twice for the same copy. That's a false framing, as I think some of the questions from this panel have, gone back and forth with my friend on the other side have perhaps illustrated. You have to read this regulation in context with the statute and the other regulatory provisions as a whole. And the starting point, if I could just take a step back and sort of clarify how this all fits in, is that if you're going to run a business establishment service, you got to get a license. And the license that you get is an ephemeral license. It's the license you need to make the copies that are then used to facilitate the transmission to the business establishment. You just can't send music to a business establishment if you can't make the copies to do it in the first place under this license. So that's why the license is necessary. And the statute actually makes clear that that license has to be used in connection with that service. So if you have your cable TV subscribers, you get your ephemeral license for those. And if you have your business establishment subscribers, you get a separate ephemeral license for those. And you use that license to make and use the copies to facilitate the music transmission. The statute also directs the board to set rates for the use of these licenses, and that those rates should reflect what a willing buyer or seller would be paying and negotiating in a marketplace. So when you think about how this regulation operates, the regulation that directs that business establishment services have to pay a percentage of their gross proceeds, you have to ask yourself, what would a willing buyer or seller negotiate for? And here, it's pretty hard to imagine that a seller would say, well, if you got an ephemeral license for your cable TV subscribers and you have an ephemeral license for your business, if you use the same copies for both, you don't have to pay any royalties on the stuff you're sending to the businesses. That's on the house. It's pretty unusual that a seller would actually negotiate for that. And I think that's one of the first reasons why we can see that the board's interpretation of this regulation is reasonable and Music Choice's interpretation is quite unreasonable.
Can you tie that to the statutory language though, or the regulatory language?
Of course, Your Honor. I think the starting point there is subsection A1, which just says as a general matter, when you make ephemeral copies, you have to pay a royalty equal to a percentage of the gross proceeds derived from the use of those copies. It doesn't say, derived from the use of those copies solely in connection with the business establishment if you might have those copies going somewhere else. It's just as a general matter, pay a percentage equal to the gross proceeds derived from the use of the copies.
What does for the sole purpose do on your reading?
So under A2, as the board explained, the sole purpose clause connects back to in kind. And I think it's useful to note that there have been a lot of other interpretations offered back and forth today. I think that only
This is the biggest problem with what the board said is it flies in the face of everything you started out saying about how the world ought to work. It just has this bizarre rule so long as you pay. If it's bizarre, that rule is triggered when you use in-kind payments. For some reason, no one explains.
I'm not sure it's so bizarre, although I agree that it's not,
Well, you just started as your strongest argument being this would be bizarre. And yet the board said, but that's what we wanted for in-kind payments.
And Your Honor, I can try to offer an explanation here. I will say at the outset, the regulatory history is very unclear as to how the sole purpose clause even popped up because it wasn't there before the librarian added it. But I think, if I understand Music Choice's position today and their example about how they have cable subscribers and how they get their money, it sounds like, they contract with cable companies who have a variety of different streams to businesses and individuals. And so the money that they're getting from the cable companies might be quite easy to distinguish between the customers that fall under the business category and the customers that fall under the individual category. But if they have some sort of in-kind arrangement with the cable company, you can imagine a circumstance where maybe it's not super clear how to allocate that between the business stream and the individual stream.
Can you describe what an in-kind relationship would look like in this context?
I don't have a great example, Your Honor. Maybe some sort of free advertising agreement or some other exchange that doesn't include actual money or fees.
Seems like that would be kind of a rare thing, wouldn't it?
It's possible. I know that Music Choice has suggested that it hasn't accepted in-kind payments. That, of course, doesn't mean.
Very strange.
And just the fact that,
But
even
you
if
think the best reading of this regulation is the Copyright Royalty Board's reading, which is that all of that modifies in-kind payments?
I think that's certainly a reasonable reading. And that's reasonable, not just as a matter of, grammar and how the language itself reads, but it's reasonable in connection with A1 and the overall statutory scheme. And I think, if you can look at it sort of on the other side of the line, if A2 really means what Music Choice says it means, that undoes the whole operation.
What if it means what I think it means, which is that for the sole purpose is just ephemeral licenses?
I think that's possible, although, Your Honor, I'm not sure that would really give effect to the concern that the CARP and the librarian were trying to solve, which is.
Because they would have to pay for every use of an ephemeral recording.
To be sure. But I think in the regulatory history, there's a suggestion that there was a concern that gross proceeds might not fully capture in-kind payments. Now, of course.
In-kind payments are still in there in a prior clause, so in-kind payments are in.
True.
And this thing about for the sole purpose, it seems to me just to be describing ephemeral recordings.
Your Honor, I think that's a possible reading. The only reason I'm offering any amount of resistance is because I do think that the board is correct that there's, something about making sure that in-kind payments, which aren't like money and easily, traceable, making sure that those are solely coming from the business establishment revenue. So I can see why the board's regulation or interpretation in that sense would be reasonable. And that might be a little different from how Your Honor is reading it. But I think all of that underscores that there are a few interpretations here, none of which align with the interpretation Music Choice has offered, which is that A2 is actually some capacious exception to the general principle that whatever money you're getting from your business establishment service, you have to pay royalties on. Because I think as their own hypotheticals illustrate, if they just choose to use the same copy for the music they provide on all of their channels, let's say they just have one cable provider and 10,000 business establishment service providers, and they're sending the same music to all of them, they get millions of dollars from the businesses and they pay $0 in royalties. That can't possibly be what Congress envisioned when it created this ephemeral licensing scheme, directed the board to set rates that reflect what a willing buyer and seller would negotiate. And then when the board crafted a regulation that said, indeed, you have to pay a percentage of the money that you get from the business establishments. So even if the court thinks that, there might be other interpretations of this regulatory text that are more sensible, it certainly can't be that Music Choice's interpretation here, which is that it pays nothing for the value that it gets, would be correct, and that the board's interpretation would be wrong on those grounds.
All right. Is that of your opportunity to discuss the merits?
I'm just going to check my notes very quickly, Your Honor, if you don't mind. I don't think I have any other points that I wanted to bring up in response, but if the court has any other questions, I'm happy to answer them.
All right. Thank you very much, counsel. I guess we'll hear from Sound Exchange now.
Thank you, Your Honors. Matt Hellman for Sound Exchange as amicus. I'd like to say a few words about the merits, which I hope will clear up some of the questions the court has had this morning, and then a little bit about how we got here as well. On the merits, Judge Millett, I feel like you read my notes in preparing for this argument. Your adverb point is exactly right. The Music Choice position is that they only pay royalties to the extent that a copy is used solely for the BES service And they don't have to pay royalties if that copy is used for other purposes as well. That solely is not in there. Instead, as the board found, what the solely means is that
It's not solely, it's only sold.
there's only a soul, and the soul has the effect of saying that the question that the soul looks to is the consideration being given for this service, whatever somebody is paying for this service, is that only to get a BES service, or is it also to get something else? In general, and this is at page 125, JA 125 to JA 126, they make the point there that what matters is that the consideration is solely for the use of copies to facilitate the BES service. So if I pay for the BES service and only for the BES service, that's what you calculate royalties off of. That is, I think, indisputably correct. And Music Choice's position has all the problems that the panel has pointed to today.
So you agree that this is not what Sound Exchange argued to the board or what the board said, right? Because what the board said is they basically agree with everything Music Choice says about what for the sole purpose means, and just said that it only modifies in-kind payments, not all fees and payments.
So there's two halves to it, is how I like to think about it. That half that where you say they disagree, most certainly they disagree. And if you look at page 125 to 126 of the JA, you'll see them saying that Music Choice is wrong, and that what matters is that the consideration was offered for the sole purpose of facilitating the BES. That's the JA 125 to 126. Now, the next question is what consideration? And the board found that only in-kind consideration tracked to that part of the statute, not all fees and payments, dollars, I guess, that track to that. Let me say what that works out to be in practice. That means that the fees and payments that aren't subject to the sole train, if you will.
Sorry. I grew up in an age when soul train meant something else, but go ahead.
That aren't subject to that provision, those are just captured by A1, the prior provision in that regulation, which says that gross proceeds count if they are derived from the BES service. So you're still going to have to, it's still tied to the BES service, but just not quite as tightly as the sole language does for in-kind payments. And as my friend from the government said, as odd as it might be to think about in-kind payments when we haven't seen very many of them, the historical record discussed in our brief and in the government's brief shows that the CARP at that time, and really the register and the librarian reviewing the CARP's decision, heard from industry people that in-kind payments might be made in this area. And the register says, you know what, it's hard for us to tell exactly what those in-kind payments are, what they look like. And you get this sole restriction that, as the board found, ties to that, I think, for that reason. But really the key point is that sole isn't solely, to Judge Millett's point. It doesn't matter if a copy is being used for 10 different things. It doesn't matter if it's being used to play music in the Music Choice's CEO study. It doesn't matter. As long as it's being used to facilitate a BES transmission and somebody is paying for the benefit of that, that consideration is subject to the royalty requirement. And that's really that's that consideration part that is
What the part of their argument is, if you have an ephemeral copy and at the same time you're using it to facilitate the playing of a song at a BES and a consumer.
Yes.
It is not being used for the sole purpose of the BES.
It's not being used solely for the BES, but that's not what the regulation says, or certainly what it needs to mean. What the regulation says.
For the sole purpose and solely just two different ways of saying the exact same thing?
Well, it's really more that you need
solely to facilitate a BES for the sole purpose of facilitating a BES.
Yeah, I think to be complete, what the point that Judge Millett said that really spoke to me is that you need two souls. Because the soul here is there a payment that is, I'm going to use the word solely just because it's easier in English. Is it solely for obtaining a BES service? Music Choice's position is solely for obtaining a BES service for a work or a copy that is used solely to facilitate BES. It's that second solely that they need. And the first solely, and again, if you're wondering, all right, there's only one sol, what should it mean? Which one of those two should it mean? One of them, particularly on Music Choice's view, zeroes out the license. Judge, we'll get to the stakes of this case, but there are millions of dollars at stake, and something like 92% of them go away if Music Choice's position is correct, because so much of their copies are so often and in general used not just for one purpose, but for multiple
So
purposes.
can you to clarify for me, what you think the sole purpose is doing is speaking to the sole purpose of the payments
Yes.
you're receiving?
Correct. And that's what the board says at 125 to 126, the carryover sentence. That's exactly what they're saying. It's exactly what we've argued. And then I think you just get to the question of, okay, well, which payments are we talking about? All payments or in-kind payments? As I've said, the historical record shows that there was a concern about the ambiguity of in-kind payments and what they might be and how they might work. That's why this extra sole provision, the sole provision of the second paragraph of this definition comes into play. That doesn't mean that A1 already accounts for the other, already requires a nexus between the other fees and payments, the dollars that are paid. So everything is covered. And when it comes to in-kind payments, to the extent those are ever made, there's this extra requirement that they be clear that they are solely for the purpose of obtaining the BES transmission and not for other things as well, which might happen in the case of in-kind payments, which, unlike subscription fees, are very clearly tailored or linked to the service. That's the board's reading. That's certainly reasonable. And what my friends on the other side do, turn a license that Congress created and that's been in place for a long time into an effective nullity for sound exchange.
Thank you very much.
Thank you.
Okay, Mr. Buckler, I think you asked for 2 minutes for rebuttal.
Yes, right.
Round you up to 3 because it's been a long time.
Thank you. Let me just first respond to one of the most recent things that was just argued by Sound Exchange. Now their argument is that the solely relates to the consideration that's paid, right? That makes no sense. Consideration can't be paid to facilitate a transmission to a business establishment services, just as a matter of that it's just a nonsensical. And I thought the government claimed that wasn't really the board's reasoning. So I just wanted to highlight that. But going back to some of the jurisdictional arguments that were addressed by the board, the registrar's opinion came out of a prior dispute between SiriusXM and Sound Exchange, right? It was the exact same situation. The government's trying to argue, I don't
Doesn't
know,
make it
maybe
any
it was
more right
different.
or wrong.
Well, the point is, the important part about it, in that proceeding, the board knew exactly what it was doing, okay? After the register issued that decision linking the jurisdiction to 803C4, when the board issued its final ruling, it titled it Determination for SDRs, published it in the Federal Register, okay? There was no confusion and cited 803C4 specifically as the ground. There was no talk of inherent authority. And I would also note that Judge Walton, cited in his order that's in the record, he cited the authority in the DC Circuit and the Supreme Court that to invoke primary jurisdiction, the court has to find that the agency has jurisdiction specifically to do that. That's why Judge Walton cited C4 and went through the analysis that he believed granted that authority. Also, I would just note that, this decision was published in the Federal Register, right? This was not an amicus brief, the equivalent of an amicus brief. It can only be published in the Federal Register if it's meant to have general application in the world. So trying to rewrite history after the fact about what the judges did, I don't think the court should
I
accept.
guess fundamentally, it doesn't bind anyone, right? We now know the board's view on the meaning of its regulation,
Well,
but
I do.
to, have a lawsuit resolved or a proceeding resolved, there will be an opportunity to say that's not entitled to our deference. And
I do think it binds, it has this separate independent legal, it's binding on all BES services now in future proceedings as their interpretation of that regulation, which is likely the
Does it
next,
govern these two settlements that were reopened?
well, it's the settlements.
Governing interpretation for those two settlements.
It's the interpretation of the regs that are in the CFR.
That are also in the settlements. They're adopted in the settlement.
They're also in the settlements. They were originally in the CARP and then the librarian's ruling. Then they were carried forward by settlements, but at all times they have legal authority because they're in the CFR. So
my point is that it's consequential in that this is what they have said these settlements mean. Gross proceeds means in these two settlements that we reopened.
well, I think that when they issue the new set of regulations pursuant, whether it's pursuant to a settlement or a full determination, they're adopting them as their own. It's still the Copyright Royalty Board's regulations.
I'm asking a different question.
Okay, I'm sorry.
That is, the way this occurred is they reopened two settlement proceedings, right?
No, I disagree. I don't think there's such a thing as a settlement proceeding under the
Right, they
Copyright Royalty.
reopened two proceedings that arose from voluntary settlements rather than contested determinations.
No, the proceedings arose because there was no settlement at the beginning of the period, and the settlement concluded the proceedings.
Okay, I think we're just.
But I can also cite, I can give you the sites that Your Honor asked for about this very point, about how the Copyright Royalty Board, I think if you look at section 801B7A, it talks about how as part of their roles in these rate-making proceedings, the courts can adopt as a basis for the statutory terms, the settlement provisions. And it also talks about how they have to give notice and publication of the potential settlement, but then discusses them being adopted as the determination set by the agreement, but it's still a determination.
But that is, sorry, I'm trying to get to the right page here. Seven. That's both, that says to adopt as a basis for statutory terms and rates or as a basis for the distribution of statutory royalty payments. So that's both for the rates and the distribution.
Correct.
You said this was a special thing that they do just for royalty rates. It's different from the distribution proceedings.
Yes, I'm sorry, Your Honor. There are two things that are different. What they do, if you look at little one and little two, they are, once they have a settlement in the two types of proceedings, they have to do different things. Okay, that's one distinction. There's another distinction that has
Provide
nothing.
notice to people so that if somebody, because people are going to be bound by this, right?
Yes,
And then if someone objects, then they can decline to adopt it. But these were not declined to be adopted. These were adopted.
I don't recall if anybody objected, but ultimately they were adopted. Yes.
Right. So and you don't know if anyone even triggered that proceeding. So they gave notice. Either no one objected or they chose to go ahead and adopt it anyhow, but you don't know that it was the latter. So they gave notice to everybody. And there's a very important purpose of this is to make sure everybody who's going to be bound has notice, but
I agree,
it's still
Your Honor.
not a formal determination.
Well, but it says here that it'll be the basis for their determination. And they say that in little one, the people that would be bound by the terms, rates, or other determinations set by agreement. So the idea is that
I'm just talking about our decision in IPG is what kind of determination is necessary for our jurisdiction.
Okay, well, with respect to IPG, okay, it's a completely separate thing because the holding in that case came about because there was no proceeding. That's a different distinction between rate-making cases and distribution cases, okay? In IPG, there was no dispute between the claimants at the relevant time as to how the royalties should be carved up. And therefore, there was no notice of commencement of proceeding at all. Instead, the Copyright Royalty Board sent notice to the Register of Copyright saying there's no dispute, proceed to distribute the funds pursuant to the claims that were already filed, right? That's not what we have here. Here, there was a notice in each of these proceedings, there was a notice of commencement, various participants filed notices of intent to participate. There was, a preliminary schedule set, and ultimately it settled, but it settled during a proceeding. In IPG 1, and keep in mind, there's also IPG 2 and IPG 3, right? Because for other categories, there were proceedings that went forward, and therefore this court did have jurisdiction to hear. And I would also point out, it's important, in addition to the determinations, any of the ancillary rulings that are part of a proceeding get wrapped up in that determination. So I would also point out, the government was making when they were discussing the appellate jurisdiction provision, they kept saying only final determinations are appealable to this court. That's not what it says. It says any determination under C.
That's
And-
fine. I just don't know why you're arguing for jurisdiction. I don't know why you wouldn't be happy for us to say this thing was a frolic detour and, go back to the district court and consider it an amicus.
I'm just trying to respond to what I think was an incorrect argument. That's all.
Okay, I very.
Okay, thank you.
Thank you to all counsel. We really appreciate your time and help. And the case is now submitted and the court is going to take a 5-minute recess.
This honorable court will now be
was very popular. She judging for the rest. She's been let us know a long time now, for a long argument. Yeah. it is. So did
Maybe, I don't know, I can't remember why, I think it was in Mexico for an argument, can't remember, but I didn't intend.
you made trouble with the recognition.
You just never know, it's like, sometimes you get something in like 2 weeks is fast, but a month, sometimes you're waiting like, I waited 4 years for a decision.
Stand, please. This honorable court is again in session. Be seated, please. Case number 24-7135. Ramona Matos Rodriguez et al. Versus Pan American Health Organization appellant Joaquin Molina et al. Mr. Volchok for the appellant, Mr. Duggan for the appellees.
Thank you, counsel, for your patience. We've had a number of complicated cases today.
Understood, Your Honors. Thank you for your time. May it please the court, Daniel Volchok for the Pan American Health Organization, especially appearing solely to contest jurisdiction and without waiving PAHO's privilege or immunities. May I please reserve 2 minutes for rebuttal? I'd like to start by summarizing my arguments on both appellate jurisdiction and the merits. On jurisdiction, we submit that this case is controlled by the court's decision in Neamble, and that even if Neamble had never been decided, there would be collateral order jurisdiction under Supreme Court and this court's precedent. On the merits, we submit there are 2 overarching flaws with the challenged order. First, the discovery rests largely on new theories of jurisdiction, theories that were not addressed in the prior appeal and that cannot support any discovery because as a matter of law, they cannot establish jurisdiction. Second, as to their one live theory of jurisdiction, their one non-new theory, plaintiffs have not shown, as this court's precedent requires, that any discovery is necessary to resolve jurisdiction in light of the information that PAHO has provided. So with that summary, let me turn back to jurisdiction. Neamble held that an order for jurisdictional discovery against an IOIA immune entity qualifies for collateral order appeal. Now, plaintiff's principal argument about Neamble is that it applies only when there has been a prior appeal in a litigation. But no case has read Neamble that way in the decades since it was decided. There's nothing in Neamble itself, the opinion, the reasoning, to support such an artificial limitation. And such a limitation doesn't make sense because, as I said, Neamble was about collateral order jurisdiction. And
So there was a very interesting amicus brief filed by these professors, William Dodge, Mark Feldman, and Edward Swain. And I wonder if you could address their argument about Neamble. They said that, Neamble, so Neamble was about organizational immunity, and it held that a district's court's grant of discovery against an absolutely immune defendant is sufficiently conclusive to qualify for collateral review. And the professors say in JAM versus International Finance Corp in 2019, after Neamble, the Supreme Court held that the IOIA confers the same immunity on international organizations as FSIA does to foreign governments, and that international organizations are not absolutely immune from suit. So Neamble was based on case law we had before JAM that said that their organizations are absolutely immune unless they waive their immunity. JAM comes along and says, no, that's not true. They're not absolutely immune. So the professors say Neamble is based on law that's been overturned and overruled, it doesn't apply. You can't rely on it.
So the last part is their assertion, Judge Pan, is not correct. So absolute immunity was the term of art that was used prior to JAM to describe IOIA immunity. And as you indicated, even before JAM, it was something of a misnomer because IOIA immune defendants before JAM were not absolutely immune. There was one statutory exception, express waiver. And it's certainly not correct, as I think the academic amici are suggesting, that JAM was holding that a jurisdictional discovery order against an international organization qualifies for collateral order review only if the international organization is genuinely, truly immune. And the reason absolutely immune, the reason I say we know that can't be right is because in Neamble itself, this court rejected an argument from the international organization there, the IMF, saying that it was categorically immune from any jurisdictional discovery, could not be ordered under any circumstances. This court rejected that precisely on the ground that, no, you are not absolutely immune. You can be sued if there's an express waiver. So what Neamble was saying was that in order for jurisdictional discovery against an immune international organization, that has immunity, I should say, an international organization that has immunity unless a statutory exception applies. There was one exception at the time of Neamble, waiver. There are more now under JAM, the FSIA's
I
exceptions.
guess waiver doesn't seem to be the same type of provision as the other ones that are contemplated. But to put it in context, before Neamble, with respect to sovereigns under the FSIA, we also had some other cases, I guess Beecham and Pierogi or something. Anyway, that seemed to suggest that for jurisdictional discovery orders, that is not something that is subject to interlocutory appeal, but there is a safeguard for a really abusive one, which is mandamus.
So
So it seemed that Neamble came along and said, we're talking about organizational sovereign immunity, and it went off in this direction about absolute immunity. But then JAM comes along and says, no, we're going to treat FSIA and IOIA the same. And now, why isn't it the case that Beecham and I'm forgetting the name of it, Papandreou, thank you, Papandreou applies because it's all the same thing. And now mandamus is your remedy. Otherwise, you don't get to appeal a jurisdictional discovery order.
So a couple of responses. In Beecham, there was not a jurisdictional discovery order at issue. It was an order telling the parties to come up with a discovery plan. And this court said that does not impose anything more than a de minimis burden. And so you don't qualify for collateral order appeal. Neamble said the same thing in refusing to take interlocutory jurisdiction over the district court's denial of the IMF's motion to dismiss, because it was a motion to dismiss without prejudice based on a new complaint having been filed. And so this court said all that the IMF had to do there was refile a pre-existing motion to dismiss, not enough of a burden to qualify for collateral order jurisdiction. But Beecham did not involve that kind of order. Now, Papandreou did.
Yeah, be that as it may, right? You're asking for a categorical rule that jurisdictional discovery is subject to this kind of interlocutory appeal. And Papandreou,
yes.
Papandreou and Beecham suggest that, no, if you want to do that, it's mandamus. And there's also the argument, like, this is a lot of, I guess there aren't a ton of these jurisdictional discovery orders, but the idea is if we were to find that we'd have to distinguish Papandreou and Beecham, but also we'd have to find that there's some categorical reason why we should allow jurisdictional discovery orders to be immediately appealable. And there are a lot of reasons why we probably don't want to do that have been addressed by the district court and other parties about grinding this to a halt, giving you too many bites of the apple to appeal, et cetera.
A couple of responses, if I may.
Yes.
First of all, we know it has to be categorical. Supreme Court has told us that if cases are subject to collateral appeal, you do that on a category basis, not on an individual basis. So we submit Neamble holds that jurisdictional discovery orders against IOIA immune organizations are a category of orders that qualify for collateral order appeal. On Beecham, you don't have to distinguish Beecham. Beecham is factually different. And I submit when you read Beecham, Judge Pan, I submit it's quite clear. The court was saying, gee, if there had been actual discovery, that might be quite a different case. But here we don't have that. So no collateral order. Now, in Papandreou, I think Papandreou is a great case for us. Papandreou makes absolutely clear that some type of appellate review, immediate appellate review, is necessary because of the seriousness.
But that was mandamus, though.
It was mandamus because, well, a mandamus petition was filed, and the amici suggests that if collateral order jurisdiction had been available, this court could not have granted mandamus. The reason that's wrong is that no party in Papandreou, and I've looked at the 6 briefs from 1997, the petition, the response, the 3-party briefs, and the U.S. amicus brief, none of those 6 briefs even mentions collateral order jurisdiction. And I don't mean mentions it only as a possible alternative remedy that would foreclose mandamus. They don't mention it at all. They don't cite Cohen versus
Point is,
Beecham.
it assumes that there is no other alternative.
This
It
court,
assumes that collateral order review isn't available because you wouldn't get mandamus if there were any other way to do it.
correct, but this court was not presented with the argument. The
The
court's obviously
jurisdictional factor, though, that we would have had to consider on our own.
no, because mandamus jurisdiction is not jurisdictional in that sense, save so long as the mandamus petition would be issued in aid of jurisdiction. So when this court dismisses mandamus petitions for lack of jurisdiction, it's because someone has sought mandamus to a court over which this court does not have an appeal. This court has said we can issue mandamus to protect our current.
We have said that elements of mandamus are jurisdictional.
I don't think that is correct, Judge Millett. I could be wrong, but this court has dismissed mandamus petitions only. Well, but in any event, Your Honor, even if it's jurisdictional, the argument was not presented. So whether or not this
Sometimes we
court,
think of jurisdictional arguments on our
no
own.
doubt about it.
This
And
morning, no doubt illustrates.
no doubt about it. And my point is no one raised it to this court. But I do want to get back to, we're not just relying on Neamble. I said at the outset that even if Neamble had never been decided, there would be collateral order jurisdiction. Look at the process and industrial development case decided 5 years after.
Can we go back to, like, we all agree that if we're going to find jurisdiction, it would be a categorical thing under the collateral order doctrine. What are the big interests that make it so imperative that, we relax the normal rule that you need to get to final judgment before we get here? That's presented by a jurisdictional discovery order.
The interest that this court has recognized in Foremost McKesson versus Iran, in Papandreou itself.
But that's about immunity itself. I'm talking about jurisdictional discovery about immunity.
So even in Papandreou, Your Honor, this court said sovereign immunity is an immunity from trial and the attendant burdens of litigation. The infliction of those burdens may compromise it just as clearly as would an ultimate determination of liability. So what this court has said in case.
The sovereign immunity decision, but I'm talking about a discovery order to determine if there is sovereign immunity.
Right, but Papandreou said what?
Does the courts have jurisdiction to determine jurisdiction?
No doubt about it.
And so why? I don't understand.
The interest
separates sovereign immunity from discovery to determine.
So the language that I just read from Papandreou was obviously about a jurisdictional discovery order as we were discussing. So what this court has recognized in Papandreou and elsewhere, the PNID case that I just mentioned, I'm happy to quote as well. That's on page 23 of our brief, 38 of the plaintiff's brief. This court has said ordering jurisdictional discovery is a form of denial of the immunity, and it is a permissible form to the extent a court that the discovery is actually necessary to determine jurisdiction. This court said in Papandreou, in Neamble, in other cases that jurisdiction, when there's a disputed fact about jurisdiction, courts can order discovery that is necessary. That is the word you see in Papandreou, Foremost McKesson, Neamble, to order the discovery that is necessary to resolve jurisdiction. Now, we submit they haven't done that. That's a merits question. I hope to get to that in a few minutes. But the interest that justifies relaxing the final judgment rule is protecting the immunity that Congress conferred and the president conferred in the IOIA. It's the same interest that you see in cases like PNID, where this court granted collateral order.
But doesn't your argument assume that there actually is immunity? But that's the question that we're trying to determine.
There is immunity until an exception has been established. And as you said, that's the question of jurisdiction. The court has jurisdiction to determine its own jurisdiction. So the federal courts can pursue the discovery that is necessary.
You mentioned PNID. Am I right? Part of what was going on there was that the effect of the order was requiring the defendant to litigate parts of the merits before the immunity question was resolved. And the holding in that case is, well, you can't do that. And that, if you have an order that does that, requires litigation of the merits before immunity is resolved, you get an immediate appeal. I
Correct.
think the lesson of that would be, if this was an order that had jurisdictional and merits discovery, it would certainly follow sort of immediately that we would have appellate jurisdiction. But if you have an order like this one, that at least on its face is about jurisdictional discovery only, I understand you still have an argument based on the language in Papandreou that there is a sovereign interest in play, but you'd have to agree it's a lesser interest than requiring a potentially immune defendant to litigate the merits.
Well, so what
than to require it to respond to jurisdictional.
So what the court said in P&ID was that imposing this is almost an exact quote, imposing the burdens of litigation on a foreign sovereign is precisely what triggers the second and third factors of the collateral order doctrine. Now, that was merits there, Judge Garcia. But first of all, my submission is that the order here is significantly more burdensome, simply briefing the merits as opposed to all of the discovery that has been ordered. And we submit that the discovery here is in fact not limited to that is our entire merits argument. The discovery is not limited to what would be appropriate to resolve jurisdiction. That's the very reason we say under Niambo, under P&ID, Papandreou, Foremost McKesson, et cetera, there is collateral order jurisdiction. Now, as I said, sorry, Judge Pan, as your question alluded to, there is this argument that you hear from plaintiffs and the academic amici that if there is appellate jurisdiction here, defendants may be able to drag out cases like this for many years with interlocutory appeal after interlocutory appeal. A couple of responses on that. Number one, as our reply brief points out, the Supreme Court rejected much the same argument in the Coinbase case, explaining that courts have robust tools with which to prevent litigants from dragging out litigation with frivolous interlocutory appeals. And one point I think is important that follows from that, Your Honors. Plaintiffs.
Thank you.
What tool that we can apply to a foreign sovereign?
So to prevent frivolous interlocutory appeals, the court talked about a district court certifying an appeal as frivolous. What I was about to say is that plaintiffs have not, in this case, did not ask the district court to do that.
There's a categorical rule under Mohawk. So categorical rules sweep in meritorious and frivolous.
I do not understand the Supreme Court's precedent, including cases like Coinbase, to say that even if there is jurisdiction, because the fact that there's collateral order jurisdiction, just like the fact that there's ordinary appellate jurisdiction after a final judgment, does not prevent a district court from certifying an appeal as frivolous, a court of appeals from dismissing an appeal as frivolous. I mean, this is.
I've never heard of that. There are courts that certify appeals as frivolous?
Yes.
They do.
Yes. I mean, this is exactly what the Supreme Court said 2 years ago in the
District court do it.
I'm sorry, I didn't hear your
What
question.
do they do? They just sort of say, you filed this notice of appeal. I think it's frivolous.
Yes, I am prepared. I am certifying this appeal as frivolous. Now, of course, it is then up to the Court of Appeals.
Find it to us.
I'm sorry. I think the implication is certifying it to the Court of Appeals. I can't do better than cite this case to Coinbase from 2 years ago, which also involved interlocutory appeals, right? That was
Certify it as frivolous, but guess what? Everyone has to go through the appeal process. There's delay, there's briefing, there's expense. Then what
correct.
happens?
Well, what the Supreme Court also said, Judge Millett, you asked me about the tools that the Coinbase court identified. Certifying an appeal as frivolous is just one of them. Supreme Court in Coinbase also talked about summary affirmance. This court can dispose of appeals without full merits briefing and oral argument. Sanctions as a possibility for litigants who are.
Can we impose monetary sanctions on a foreign sovereign when the question of immunity is still open?
So I was answering the court's question about what tools the
I am
Coinbase
asking
court.
in this situation,
I-
when we're dealing with foreign sovereigns, we
Yes, I
can
believe.
without even deciding whether they're subject to the jurisdiction of the court, impose what damages sanctions?
I don't think it would be a damages sanctions because there would be no showing of damages, but it would be for litigation conduct. This court.
Litigation costs is a damage.
Okay, sorry, litigation costs, attorney's fees, that sort of thing. Yeah, I think that.
You're conceding that can be done to foreign sovereign?
I'm sorry, Your Honor, I may have misunderstood your question.
Jurisdiction?
I'm saying that is what the Supreme Court identified as one of many tools that.
Applicable, did the Supreme Court say it was applicable to a foreign sovereign?
No, because it was not dealing with a foreign sovereign
Exactly.
immunity
It's my
case, but.
point. That's why I think you're getting this question from me and Judge Pan. So if you're willing to concede, I don't know how you can concede this.
I can't concede that on behalf of any international. Certainly, I couldn't do it beyond PAHO, but I don't think I can even do it on.
You can, yes.
PAHO's,
concede
yeah.
for your client that if say we said an appeal was frivolous, pay, court fees to this court and to the opposing counsel, write them a check for, or Venmo for some large amount of attorney's fees. Enforceable or not?
I don't know that that would be enforceable, Judge
Okay, well,
Millett.
this doesn't sound like much of a protection against frivolous appeals.
It's a very important protection, Judge Millett. This court has,
Completely unenforceable and inapplicable.
I'm not,
Sovereigns.
I don't know if it's enforceable or not, Judge
You don't
Millett.
know that it is.
I do know.
Wait,
that
time out. You just said you don't know if it is enforceable, correct?
I agree with
Okay,
that.
then how can you tell me it's a relevant, helpful limitation on frivolous appeals when you can't even tell me if there's anything remotely enforceable we could do to rid ourselves of frivolous appeals?
Judge Millett, I was answering your question about what tools the Supreme Court identified in the Coinbase case.
No. Well, our question was what tools could be applied in this context.
Okay, well, the district court certifying the appeal as frivolous, this court summarily dismissing the appeal, and plaintiffs did not ask this court or the district court to do either of those things. And because, and in Coinbase, it's
that the things that you're referring to are just not realistic. Like we get lots of appeals that some might think are frivolous, but I have never seen a district court judge certify an appeal as frivolous. You're asking a judge to opine like that. I guess I'm going to fly a motion for a frivolous certification, which I've never seen. And then you're saying that it would come up here and we could sanction somebody for filing a frivolous appeal. Like, I don't think we've ever done that.
so I'm drawing
Like we might say, we haven't done money damages, but sometimes we would say you can't file another one unless you get some prolific pro se litigators. We'll say you need to get permission before you file again or something like that. But monetary damages for filing frivolous appeals, like none of this sounds realistic to me.
So I am drawing all of this directly from the majority of the Supreme Court's
Which wasn't
decision.
dealing with foreign sovereigns. So if we could just maybe reason from first principles for us in a situation involving foreign sovereigns, what is a limitation other than us having to go through summary affirmance, which for comedy reasons is not something we commonly give in foreign sovereign cases.
So there
If
are,
you want us now to treat them the same as repeat litigants, let me know.
so there are always burdens and delays that accompany a ruling that a class of orders is subject to collateral order appeal. There would be in this circumstance, but Neamble held that class is available. Now, my second response on this argument
Neamble didn't talk about class or categorical decisions at all. It decided a case in the context in which there had been no ruling yet at all on the merits of a motion to dismiss on immunity grounds.
And that is exactly what we have as to most of the discovery here, because most of the discovery here is based on new theories of jurisdiction, as I articulated at the outset. As to all of those theories, which I'm happy to discuss with the court's indulgence, all of the discovery that rests on those theories.
Mayor, I just want to make sure if Judge Pan wants to ask any more about if there is anything remotely realistic that could be done to prevent a foreign nation from appealing every discovery order.
Well, we certainly know, were you going to? We certainly know that in the decades since Neamble was decided and in the many more years that there have been cases under the FSIA, there has been no flood of jurisdictional, of abuse of appeals like this. In fact, what the academic amici point to two examples of what they say are litigations that have gone on too long against foreign sovereigns because of interlocutory appeals. So the Simon versus Republic of Hungary, the Helmerich and Payne litigation, both in this circuit. What they overlook is that in both of those litigations, lower courts interpreted foreign sovereign immunity too narrowly, and it was only because of the availability of interlocutory appeal that this court and or the Supreme Court was able to correct those misreadings and avoid foreign sovereigns being subjected to excessive litigation burdens, which goes directly to my second point, responding to this argument about interminable interlocutory appeals. The second point is plaintiffs and their amici are ignoring the other side of the balance. As I said, whenever a class of orders is recognized as satisfying collateral order jurisdiction, there's delay, there's some risk of this abuse, but it is accepted in light of the orders, the values on the other side. When foreign sovereigns and international organizations are subjected to excessive litigation burdens, which is what will happen more and more if interlocutory appeal is denied in circumstances like this, that is harm to the public because all the resources that the international organizations have to invest is not available to serve their public serving
You're
functions.
talking here about like this case. So I want to clarify one thing. When you talk about the one live theory of a jurisdiction for which they are allowed to get discovery, you're talking about the claim that was recognized by this court in the prior Rodriguez appeal about transfers of money for.
Correct. Allegedly moving money for a fee between.
If a district court says, I think this is an additional relevant question to jurisdiction. Is that sufficient? Does that make it them, is it then permissible? Or are you saying that the only discovery that can be allowed is whatever theory is first, one single theory that is recognized in appeal?
Well, our position is the latter, that you can get jurisdictional discovery only on a theory that has been held to be facially viable, assuming a facial motion.
By whom? District court or court of appeals?
Well, the district court, if a facial motion to dismiss is filed, the appellate court, if an appeal is filed, obviously if no appeal is filed, none of this comes into play. But I do want to underscore 2 points.
Well, before you underscore points, I got to get my confusion straightened out here. So in this case, we have the facial appeal and we recognize a theory. You want to call it the one single formulation of it. There are actually multiple formulations of it in that opinion. And as discussed at oral argument, I think it was you or but counsel for Pan American had a much broader reading of it at oral argument. But in this case, went back to the district court and you filed a second motion to dismiss.
Yes.
You called it a factual motion to dismiss. So my first question is, if we're concerned about abuses, why didn't you file both at the same time?
The factual motion to dismiss imposed substantially more burdens on PAHO because it required PAHO
As anything, you tell us in your brief, you voluntarily turned over these documents. And so you could have voluntarily, it didn't take any more work to voluntarily turn those over after our ruling rather than it could have before. And then you could have done one appeal to this court.
Right. But if
what happened procedurally here is what has our radar up on, seriatim 12B1 appeal after appeal after appeal. So you could have done that voluntary disclosure beforehand and then filed in a single motion your facial and factual motions to dismiss. Couldn't you?
Yes, but we
chose not to.
We did because that would have required us to incur the burden. And if this court had agreed with us on our facial motion to dismiss, then this litigation.
Now they have to incur the burden and we have to incur the burden of appeal number 2, raising 12B1 motion to dismiss.
So plaintiffs have not, to my understanding, raised any objection to the possibility of a facial motion to dismiss followed by a factual motion to dismiss.
Are you aware of that ever happening? I can't find another case where 2 12B1 motions were split like this.
In the DeCepel case that is cited in our reply brief and in plaintiff's brief, so DE space CS.
I don't know what that case is.
It was a case involving the allegations were expropriation of artwork and breach of contract involving Hungary and World War II, expropriation of artwork. Hungary was sued. Case first came up on a facial motion to dismiss, went back down. Then a factual motion to dismiss after discovery was filed.
After discovery, so that was that sort of summary judgment after discovery.
It was, sorry, I apologize. It went up on a facial motion to dismiss. It went back down for jurisdictional discovery.
Right.
And then at the conclusion, so not merits discovery and not summary judgment.
Conclusion of jurisdictional discovery.
Correct. And so my assumption.
This is before your factual motion to dismiss is before any discovery. And your whole rationale is that they don't get any discovery because look at all these documents we gave you. So I'm going to ask again, has there been a case where it comes up on a facial one and we say, here is under 12B1 standards, a legally viable theory for having jurisdiction in the case for abrogating the sovereign immunity under 12B1 standards, thing could change. Go back, have jurisdictional discovery, and then you jump in and say, hang on. of jurisdictional discovery. We just turned over a whole bunch of documents, and on the basis of those documents that we have selected ourselves, we're going to file another 12B1. That's what I'm asking you.
So all of the parties and the district court have agreed there does not appear to be a case exactly like this one. The closest is probably Neamble, because as I said earlier,
That's not like this at all.
it's very much like this case, Judge Millett.
Very much unlike it, because there you did not have already one appeal, one legal determination, both by the district court and this court, as to a viable theory for jurisdiction.
And if they were only seeking discovery on that one viable theory, then I would understand why
That's
Neamble is.
back to my, okay, so why, given that you have filed a factual motion to dismiss, and given our decision in Angola, Phoenix Consulting versus Angola, which says when a factual motion to dismiss is filed, the district court cannot rely on just the allegations of the complaint. There has to be discovery allowed for the plaintiffs to respond to that factual motion to dismiss that, and then the court will decide the factual motion to dismiss after jurisdictional discovery on the factual motion to dismiss.
What this court has said in case after case, I do believe it is in Phoenix Consulting, but it certainly is in cases both before and after it, like Foremost McKesson, Papandreou, and Neamble.
I want you to answer my question
Yes.
about the language from Angola.
The holding in Angola, in Phoenix Consulting, was that when a factual motion to dismiss is filed,
It must give I'm on page 40. It must give the plaintiff ample opportunity to secure and present evidence relevant to the existence of jurisdiction on the factual motion to dismiss grounds.
yes, and this court has made clear that first of all, it's made clear in Papandreou that in fact, relevance is not the standard. That's not enough in the IOIA context. And it has made clear, as you would expect, that what plaintiffs are entitled to, what a plaintiff in this circumstance is entitled to, is the discovery that is necessary to resolve the jurisdictional dispute. And Judge Millett, to your question, we say they don't get any discovery. The reason we say they don't get any discovery, even on what we call their one live theory, the moving money for a fee theory, is because they have not, we submit, satisfied Neamble's standard, which it drew from the Second Circuit. Fifth Circuit has said exactly the same thing, that you get discovery that is necessary to verify specific allegations of facts.
Court found it necessary here. What I'm asking is, you have argued here that the only thing they can get jurisdictional discovery on is the one theory that came up to this court.
Correct.
When in fact, we have said that when you file a jurisdictional motion to dismiss on factual grounds, a factual motion, the court has to give them jurisdictional discovery that is responsive to that motion to dismiss. And nowhere in your briefs have you argued that the jurisdictional discovery here exceeds the bounds of issues raised in your factual motion to dismiss. You argue only that it exceeds the payment for a fee, as the one little abbreviated line from a prior appeal you want to use. That's all you've argued. And you keep talking about the one live theory, the one live theory. But in fact, your factual motion to dismiss raises other issues. And as long as the district court's jurisdictional discovery doesn't go beyond what is necessary to respond to your jurisdictional motion to dismiss, which you haven't argued it is, then we have to get it.
Our factual motion to dismiss absolutely did not go beyond the one live theory. We went.
Okay, that is something the district court here said and explained why the discovery it allowed, including the stuff about the operations of administration of the program, was tied to your factual motion to dismiss. You have not argued about that. All you've argued about is the one live theory from the prior opinion. So you have forfeited those arguments.
I'm
So
sorry.
It seems to me you're asking us to, I know you're going to disagree, so I'm going to finish it. You're asking us to say this discovery, I don't know if you even mentioned your factual motion to dismiss in your opening brief, but your argument here is that discovery has to be tied to what you call the one live theory recognized in our appeal, and that all the discovery here doesn't fit that one live theory about the fee for transfer of money. But the district court explained why it was necessary to respond to your factual motion to dismiss on jurisdictional grounds.
I don't think the district court did explain that, Judge Millett.
Where have you argued in your brief, in your opening brief,
Mhm.
that the district court's explanation for why the connection between the discovery that allowed and your factual motion to dismiss doesn't exist, as opposed to what we said in our opinion last time. Because
For example, pages 37 to 39, we walked through significant portions of the jurisdictional discovery requests and explain why granting jurisdictional discovery on each of those was impermissible. Some of
Yes, you
those,
say impermissible because it wasn't the one live theory.
that is some of it, Your Honor. That is not the entirety of it. We get to discussing the one live theory.
Where do you discuss your factual motion to dismiss here and the content of it, the information you provided, the arguments you made? Where is that discussed in here?
Well, we discussed it certainly in the procedural history section where we are discussing how we got to this point, but we discussed the errors to the extent the discovery rests on the one live theory. We discussed those errors starting at page 47 of our brief and going all the way to page 57. Now, I don't want to skip over the fact that we challenge a lot of the discovery as going beyond the theory, principally resting on the theory that the administration of the Mace Medicos program was carried on in DC. The district court said that on JA 1241, and that was the entirety of the court's explanation for 5 of the 13 jurisdictional discovery requests. Now, this court held in the Youngquist case, JUNGQUIST, this court held, quote, administering a national public health program is a non-commercial activity, end quote. That is a quote from plaintiff's brief to this court in the prior appeal at the top of page 32. They said, and Youngquist did in fact hold, administering a public health program is a non-commercial activity. The United States said the same thing to this court in the prior appeal on page 25 of its brief. The Second Circuit held the same in the Anglo-Iberia case that we cite. So even if PAHO administered Mace Medicos from DC, that as a matter of law under Youngquist, the other authorities I just cited, would not be a commercial activity, could not establish jurisdiction. And the district court agreed on JA 1239 that if a theory can't establish jurisdiction, it necessarily can't justify any jurisdictional discovery. Now, we made this point about administration of a public health program at some length in our opening brief, as our reply points out. Plaintiffs do not answer it at all. They don't cite Youngquist. They don't cite Anglo-Iberia. They don't cite the United States' amicus brief. So with this point having been conceded, and with this being the...
Hang on. You just admitted that your factual motion to dismiss raises the issue of how the program was administered.
No, it does not. They are seeking discovery on those things, Judge Millett. We put...
Said it was all administered from?
I'm sorry?
You just said that it was all administered. How it would, you introduced documents to show what you were doing under this program and what you were not doing and where you were doing it.
We introduced documents to answer the one theory that this court held facially stated a claim, assuming the truth of plaintiffs' factual allegations in the complaint. Moving money for a fee between Cuba and Brazil. So we provided contracts between Brazil and Cuba, Brazil and PAHO, PAHO and Cuba, including agreements showing the exact amount that PAHO was paid by Brazil in connection with Mace Medicos. We provided bank statements.
Here's what I see, counsel. I mean, you have a perspective and a position on what's relevant and what's not based on your reading of the prior opinion by the circuit court, and you litigated in the district court accordingly. District court disagreed with you. And, just one example of this that kind of struck me was that you take the position that, oh, we've given you all this banking information about where all the money we got from this program and went to our Banco de Brazil account, and then it went out to, these different areas, to Cuba, et cetera. And then there was this 5% fee. You don't talk about where the 5% fee went because you say that's not moving money for a fee. That went to our administrative expenses. That's the kind of thing that we do, to pay for our administrative expenses. But the point is, neither the opposing side nor the district court has to accept your representations about that 5%. They can say that's evidence of moving money for a fee. That's the allegation. So we want discovery about where did that 5% go? And part of that might include, logically, all the money that came in from Mace Medicos. Where did that all go? Because that could be part of nailing down where did that 5% go to, because they might not agree with you that 5% is not moving money for a fee. You see,
Number one.
And the problem is, every time they disagree with you, you're saying you get to come up here and appeal. And that seems untenable to me.
Several,
Anything that's related to your immunity, you think you can come up here and appeal. This is jurisdictional discovery. There's a lot more that has to happen. What if we disagree with you, send it back, and you have another dispute about it? Are you going to come up here again?
so Judge Pan, several responses. We did provide information to plaintiffs about where the retained funds, the 5%, was moved after it was recognized by PAHO. So Brazil deposited it into one account in the country of Brazil. Our declaration explains that once PAHO recognized 5% associated with a particular direct cost, deemed itself that money to have been accrued, our declaration explains, it's in the record, that it was moved to another account in Brazil. So factually, we have addressed it. Now, to the point,
And did
plaintiffs,
it ever come to America? You don't want to say.
they have we believe that under Neamble says you,
I understand that's what you believe, but that's
Sorry.
my whole point is you could be wrong. The district court could disagree with you. The other side might want to test your theory. The point is you could be wrong, and you shouldn't be able to run up here and complain to us every time somebody disagrees with you on a jurisdictional discovery issue.
Neamble squarely holds that jurisdictional discovery against an IOIA immune entity is available only if the plaintiff can make a specific, well-founded allegation that
I understand that, and there's a dispute between you and the other side about what that specific well-founded allegation is. And you think that you should be able to appeal every time that is disagreed with by the district court. And I think that's untenable. Because even just on the facts of this case, it seems to me that what the district court did is completely normal discovery to allow the other side to test the allegations that you've made, which they're entitled to do. But that's been cut short because you decided to take an interlocutory appeal. And I have no confidence that if we send this back, because we also disagree with you, you might find another thing that you want to appeal to us.
they are not entitled to that information under Neamble, McKesson, Papadreou.
According to you, that's your position.
Well,
They get to test it. They get to get discovery and make their case as to why you are wrong.
My position is that under binding precedent, under this court's cases that I just recited, they do not get that unless they can make a specific well-founded allegation.
And maybe the district court thought they did.
He did
And
not.
maybe they did.
Were those responding to factual motions to dismiss that discovery in those cases you've cited?
Yes, I believe, I am not sure of the answer to that question, Judge Millett, but they certainly all involved jurisdictional discovery.
That's a very different thing. So what I'm saying, we have a case that says when a factual motion to dismiss is filed, the district court must allow responsive jurisdictional discovery for them to test, counter, to be in a position to counter or not. They could send up the white flag. Those theories propounded there. And so, we haven't, even for sovereigns, we have an adversarial system of justice. We don't let one party come in and go, here are the records I choose to give you, rule on this district court.
That is correct.
So
And if
do you
they-
agree that the district court under Phoenix Consulting had to allow responsive discovery necessary for the court to be able to decide your factual motion to dismiss? Do you agree with that?
Yes, because you said necessary to resolve the
That's fine.
factual.
I'll use the
Yes,
word necessary all day if that's
yes,
what you want.
and
All
I
right.
do agree.
Okay, all right. And where did you argue that, given the things that you raised, where you talk about the 5% fee and what it was for, you talk about administration, what occurred in the U.S., what didn't occur in the U.S., where did you argue that that was invalid? Because when the district court said, I'm allowing that to respond to the factual motion to dismiss, and all I read in your brief was that's not consistent with their affirmative argument for jurisdiction on the prior appeal.
In
You
se-
cited those pages, but I think those are all talking, as I read them, in terms of your rationale for, the one live theory. There's
47.
two live theories. I
Yes,
guess,
the
is
one
my
live,
theory.
sorry.
There's two live theories. There's a live theory that they affirmatively raise, and now there are live jurisdictional issues that you have raised that are factual issues, not legal issues.
We have not raised any new jurisdictional issues in our factual motion to dismiss. As I said, we provided the information responding to the one theory that the district court and then this court held.
Well, you added discussions about where it was administered. You added discussions about this fee and what it was used for. Right? You want to say it's program support costs.
Right, that
They want to
because
say it wasn't used that.
That is the dispute, although
They get to say, do they get to say that you're wrong? That was not a program support cost.
what they get to say.
They get to make that argument.
Sure, that's a legal
They get to
argument.
have discovery to allow them to make that argument.
Only if they can make a specific.
Do they get to have discovery to counter the argument that you have relied on to say why there is no jurisdiction?
No under Neamble unless they make a
I'm
specific.
just telling you.
I'm-
What more do they have to say? Neamble did not involve a case where the defendant had come forward and said, here are factual questions that provide a basis, your resolution of these factual questions.
And neither did we. Neamble.
Excuse me, you filed a factual motion to dismiss. Look at these facts. Look
Correct.
at these please, just let me get it.
Sorry, Judge.
I don't
Millett.
need affirmation.
No, I appreciate
Okay,
it.
all right. You filed a factual, a non-legal motion to dismiss. A factual one says, here are facts now. We had our trip up on law. Here are facts. And under these facts, you must now dismiss this case because it shows that what we did does not count as commercial activity. We had a 5% fee. That's a program support cost. We didn't administer anything here in the US that was beyond ordinary sovereign entity types of administration. District court has to give them discovery under our decision, cannot rule on your motion until it gives them discovery. They say it is necessary for us to contest. And the district court said it's necessary for them to contest in a way that would allow me to make a reasonable ruling. They need to get information about that money trail. They need to get information about what was administered where.
My fundamental submission is that we put forth in our factual motion to dismiss evidence showing that the factual allegations on which this court and the district court relied in the first appeal, the district court prior to the first appeal, to conclude that they had a legally sufficient claim, that those critical factual allegations were
What
false.
were they supposed to have? Okay, and they want to say, because you provided documents, but imagine you have a different, far less scrupulous foreign country that comes in forwards and comes out with a, country X. Comes forward and says, here's the contract. It doesn't say anything. Here are the documents about the bank accounts. They show where the money went. None of it can touch the United States. Here are the papers that show what we were doing and where. And they're all fabricated. District court get to give discovery?
Not unless, if they can make a well-founded allegation.
They don't
They
even
have
get to
not.
test.
They have
They
absolute
don't even get to test.
plaintiffs have not come forward with any specific facts that they say are crucial to the immunity determination, let alone explain why any of the discovery that they sought or that was ordered is crucial to verify those facts. That is, our submission is that is exactly what Neamble and other cases require.
Your argument is premised on everybody accepting that you're correct on your legal theory about what this court previously held and what facts are relevant to that. And this is an adversary system. The other side gets to test your theory. The other side gets to oppose your theory. I just don't understand why you think that you get to win because you believe in your theory so much.
Sorry, I want to make sure I understand, Judge Pan, because when we're talking about the theory, it's plaintiff's
Let's
theory.
put it this way. Our decision in Rodriguez 1 formulated the theory in a couple different ways. And you keep calling it the one theory. And I understand your understanding of the one theory to be that it has to go through the Washington, D.C. bank account. But our opinion also said, we believe that the physicians have sufficiently alleged that Pahu's conduct of moving money for a fee constituted commercial activity carried on in the United States. So there are some general formulations of the same theory in the same opinion. And I think it's up for perhaps debate or discussion or a ruling by the district court about how much of this is relevant, how much of it should be subject to discovery, et cetera.
So even,
But I think that procedurally, and as Judge Millett is trying to home in on, you have put facts before the district court that you think are relevant to your theory, and you think that that should be the end of the story, but the district court has a duty and obligation to allow the other side to test your theory and to test your facts. And they might have a theory that that comports with other statements in our prior opinion that there was commercial activity carried out in the United States, even if it didn't go through a specific Washington, D.C. bank account. One of the questions they will ask is, did this go through a different bank account, not in Washington, D.C.? These all seem to be very relevant to the opinion that we issued and the issues before the court and the facts that you put before the district court. So all of this seems to be relevant, and it all seems to be very sort of routine stuff that a district court does to establish whether there's jurisdiction or not. It conducts some discovery, it makes some rulings, and it's all in the context of a case that's already been up here. And we've already said, yes, there's a viable jurisdictional discovery ground here and a viable theory of jurisdiction. And I just am puzzled by you coming in here and insisting that you must be right and everybody has to accept just what evidence you think and your view of what our prior ruling said, and therefore you win. Like, that is not consistent with the way an appeal works or litigation before the district court works.
But two responses, if I may. It is unquestionably a foundational component of our overall submission that jurisdictional discovery involving an FSIA immune or IOIA immune entity is fundamentally different than ordinary discovery in civil litigation. This is the point the court has made about the imperative of not infringing on the immunity that Congress has granted any more than necessary. That's why I keep coming back to the word necessary. My second point is that, Judge Pan, even on remand, JA 1238, the district court re-articulated the theory that it held and that this court affirmed, and it talked about carried on in the United States in as much, I'm quoting now, it was allegedly carried on in the United States in as much as the full sum of money, the money to be moved along with Pajo's fee, was placed in a U.S. Citibank account as a layover on its journey to its final destination, Cuba. So the court.
Right. So why don't you have to give the discovery where they're asking what other U.S. bank accounts have you used? Has this money gone into U.S. bank accounts, et cetera? Why do you think that that's not?
Just as in Neamble, where the IMF turned over the relevant contracts, the plaintiff still, Mr. Neamble, still had arguments about how there might have been an express waiver, and this court said not enough. You were just speculating. It's not enough to just come in and say, we think this evidence is false. They don't have a well-founded.
So they have documents that support their theory of the case. That would be different than Neamble.
If they could make a specific
I'm not asking you to restate the legal rule. I'm asking you if they actually have documentary evidence. I'm not saying they do, but if they had documentary evidence that countered a characterization inserted in your factual motion to dismiss, that would be different from Neamble, which was sort of pure speculation, as I think we described.
well, the plaintiff.
Yes, that would be different.
Well, yes, it doesn't matter, but no, because.
Sorry, it doesn't matter, but no. So it's not different. Mr. Neamble came forward with documentary evidence that we call it pure speculation.
Well, he kept pointing to language in the relevant contracts that he said were sufficient to suggest that there had been an express waiver somewhere. IMF came forward with the actual contracts and the declaration saying there is no express waiver.
It's a legal question. What a contract means is a legal question.
I agree. It's a legal question what a contract means.
Questions here.
We have come forward with the evidence showing, I do want to emphasize, we showed exactly how much with contracts that long predated this litigation. Contracts between Brazil and Pajo showing how much Brazil would pay Pajo in connection with Mace Medicos. We provided bank statements showing transactions from Brazil to Pajo in Brazil corresponding to those exact amounts. And we provided declarations explaining that what we have provided is the entirety of the relevant payments. Now, yes, if they had some basis to nonetheless say that's false, that's phony, and they could satisfy Neamble's standard, which is what I keep coming back to.
False or phony would be great for them. But also, hang on, you said relevant documents. There's in fact other arguments there are other documents that are relevant.
So we know
There are some we need to check more from their discovery. Or they have to come up. Is your position that plaintiffs have to come up with everything that they need to counter your factual motion to dismiss on their own without discovery?
My position is that Yamble holds.
Can you just give me a yes or no answer to this question? Is your position that to meet the standard, you want to try to quote to me again from Neamble, they have to come forward, they have to have the evidence already themselves?
Yes, they do not get discovery. They do not get jurisdictional
What will they
discovery.
ever need discovery for?
I'm sorry.
What will they ever need the discovery for?
Well, if they have enough evidence that they've gotten on their own to create what a court concludes, and the district court did not say this, did not say they have made a specific allegation, a well-founded allegation. Actually, the district court did say that, and I'm happy to address why that's not right. Well-founded allegation that any of the discovery they sought or that was ordered is necessary to resolve facts crucial to the immunity determination. I keep coming back to this court's case law. This is what we understand this court to have required. Unless the court has further questions, I'll save my 2 minutes for rebuttal.
Thank you, Counsel. Sorry, is it Dubin or Dubin? Dubin, sorry.
Thank you very much. May it please the court, I'm Sam Dubman representing the plaintiffs, Ramona Matos, Tatiana Cabarlo, Fidel Cruz, and Rosella Rivero. This court should dismiss Pajo's appeal because it is not an appealable interlocutory order. And if the court does entertain the appeal, it should affirm the district court's narrow and proper jurisdictional discovery order. On the subject of appealability, Judge Boasberg's discovery order is no different than any other discovery order. It's a non-final order, not subject to interlocutory appeal. The categorical rule that Pajo is urging here, its theory would basically give every sovereign or international organization 3 bites at the appellate apple categorically, as the court pointed out in its questions. They could file a legal motion to dismiss and lose, raise factual issues, object and appeal discovery orders, which, as the court pointed out, are required under Phoenix. And then once the judge takes that evidence and decides once again that they're not immune, get to appeal that decision. That's their position. That's untenable. It's contrary to everything this court and the Supreme Court has said about interlocutory appeals. The reliance on Neamble is not viable for 2 reasons. Number one, this court's prior rejection of Pajo's legal immunity argument. And number 2, the Supreme Court's jam decision, holding that international organizations like Pajo are not absolutely immune, but are indeed subject to all of the immunity exceptions of the
I mean, all
FSIA.
JAM did was expand the list of exceptions to immunity. All
Yes.
JAM did was expand the list of exceptions to immunity. That doesn't really undercut Neamble's reasoning.
Well, the application of Neamble was very clear. There was only one avenue of.
I know, but I don't understand that JAM abrogates Neamble in any way. I think that's binding precedent on us. It's just that you have a longer list now of exceptions than you had then. You had
Agreed.
one, now you have all the FSIA ones.
Agreed. I didn't say it abrogated Neamble. I'm saying that it renders Neamble inapplicable on the question of interlocutory appeal.
There's another feature of Neamble. It doesn't say a whole lot, but everything it does say is followed by a citation to a case construing the FSIA. So if we were just to say, did we think, maybe this isn't the question, but if you were to read this and ask, did this panel think it was articulating a rule that would govern in an FSIA case? And all JAM really held now is IOIA cases or FSIA cases. Sure looks like Neamble was just relying on principles we've already articulated in FSIA cases. How would you respond to that?
I think Neamble was correct in the sense that there was no other avenue other than waiver, which was, as Judge Boasberg agreed, was categorically precluded by the evidence that was presented in that case. And there had been no
Saying
prior
on the
determination.
appealability determination, it's one paragraph, and all we cited were FSIA cases. So to say we're not bound, and just how do you, in explaining why we're not bound by Neamble?
Can I, okay, let me, if you don't mind, I will answer your question if I can go through the points that the answer is that under JAM and under, your decision in 2022, there are many, many more avenues to overcoming the jurisdictional objections than the one waiver issue that was available in Neamble, which was categorically precluded. And the court articulated what those were. In this case, the threshold immunity determination was previously decided adversely to PAHO. And they made all the same arguments, by the way, that Mr. Volchuk was making to you now about that this money is sovereign, the U.S. government's brief. That was all rejected by this court. So the burden to PAHO of litigating in federal court that was the essential wrong of Nyambol has already been overcome because this court held that their legal objection is invalid. That's a major difference, and that has nothing to do with JAM. JAM raises a separate issue, which is the scope of possible issues, that can be raised by a plaintiff, to overcome immunity. And on that score, Nyambol clearly says that absolutely immune defendants, are subject, can appeal it when their immunity argument had not been addressed, and it had not been addressed. And that's a key point. So today, there are now multiple more fact-intensive paths to jurisdiction, which this court identified in its 2020 decision, and which Judge Boasberg identified in his discovery order. That wasn't the case in Nyambol. The fact-intensive nature of the current jurisdiction is illustrated by this court's 2022 ruling, which you held. The financial benefit that violates 1589B is itself wrongful conduct and occurred in the United States. To wit, PAHO received, forwarded, and retained the Mais Medicus money through its Washington, D.C. bank account. Accordingly, we believe that the physicians have sufficiently alleged that PAHO's conduct of moving money for a fee constituted commercial activity carried on in the United States. In other words, the prior ruling by this court against PAHO's immunity and JAM worked together to eliminate Nyambol's applicability on the issue of appellate jurisdiction here. The court's prior rejection of PAHO's legal immunity argument means that it's Judge Boasberg's discovery order, unlike the order in Nyambol, is not the reason PAHO will be subjected to litigation when it claims immunity. That's the result of this court's thorough decision in 2022, opening the door to these many avenues of overcoming
Some of the
immunity.
discovery you sought, the district court understood to be advancing a new jurisdictional theory under the second prong of the commercial exception, an act performed in the U.S. in connection with foreign activity.
I'm sorry, I didn't hear your question,
So
Judge
the
Millett.
district court said that some of the discovery you sought was in fact trying a new jurisdictional theory out, an act performed in the United States in connection with a commercial activity of the foreign state elsewhere. And rejected that, denied that discovery.
He specifically said that all of his orders were based upon the carried on theory,
I understand.
not the direct
You had
effect theory.
sought broader discovery than that.
Well, there was almost a 2-year process, Your
You
Honor.
had sought discovery under both prongs 1 and prong 2. Is that correct or incorrect? District court said you sought it under both prongs.
We made the argument,
Okay.
for sure. Yes,
I'm
Your
just
Honor, we
asking
did.
that. So if the district court had in fact allowed discovery on this second theory, an act outside the territory of the U.S., an act perform an act in the U.S. for commercial activity conducted elsewhere.
He could have
Did
done
he
that.
appeal that?
No, because this court held in the ExxonMobil case that the parties are not limited to just one theory under the FSIA to overcome the
I
jurisdictional
understand, but if
objection.
they just objected and said, hang on. Nobody has ruled that is a legally valid theory in this case.
Your Honor, it's not on the
They could-
table.
they could-
I mean,
They could
that's,
challenge that.
respectfully, that's a theoretical question. Judge Boasberg said that every single one of
we get
his.
to ask theoretical questions because we have to write opinions that
I know.
cover not just this case, but other cases. And so, you're objecting that they got their one appeal done and dusted, let's have discovery. But if in fact the discovery goes to a different jurisdictional theory, what answer then?
It
to an
doesn't.
interlocutory appeal?
It doesn't. I'll go through each one of the orders, Your Honor.
No, I'm not asking that. I'm asking you a legal question. If in fact discovery were granted on both prongs 1 and prong 2, could they then appeal at least a discovery on prong 2?
I would say no, because
Then that seems you're exactly in the Nyambol case.
No, because the problem with Nyambol was that they were going to be subjected to any litigation before their legal immunity argument was resolved. That simply doesn't exist
No,
here.
but they have a whole nother legal immunity argument now.
No, they got to go to court. They got to defend this case. And that's what this court's precedents
You
say.
could raise 6 new jurisdictional theory. You can invoke every exception there is under the FSIA and throw in a waiver argument as well. And all of that would be open to discovery without them being able to say, hang on, none of those are legally viable?
Well, again, that's not this case, Your Honor, but I would say.
I am acutely aware that's not this case. I'm trying to understand if we have to write an opinion on this jurisdictional question, how do we navigate this concern? Right? That the NAMBL recognizes that you got to stick to the legal theory that's been sustained.
Your Honor, NAMBL did not, as this court did, not involve a situation where the defendant's overall conduct that they claimed was immune, legally immune because it was sovereign and not commercial. That's the issue they raised. That's what this court decided. Because we're an international organization doing healthcare, money we take from Brazil is sovereign. And they cite the Youngquist case, and they cited the U.S. government's brief that said, these international organizations, everything's sovereign. Well, Judge Boasberg rejected that, and this court rejected that because what they did was committed a crime under the Trafficking Victims Protection Act by benefiting from participation in a human trafficking operation.
They committed a crime.
I beg your pardon?
We did not say they committed a crime. That's your characterization.
They violated a criminal statute with civil remedies, Your Honor.
That is your argument. We're talking about, we upheld one theory, we send it back, and if the discoveries start slopping over into a different jurisdictional theory,
it doesn't.
They wouldn't get to appeal that.
Again, our position is it does not violate the rule. There are two issues here.
Once one theory of jurisdiction is upheld on appeal,
there's no immunity.
Everything's open.
That is a classic issue that could be resolved in a final order if it turns out that extra discovery that Your Honor is saying, which again, I reject the principle that it's even applicable here because Judge Boasberg said he's not ordering any of
What happened in
that.
this case? I'm asking
Understood.
legal line drawing here.
I would say 2 things. Number 1, it does not reach the level of encroachment on the defendant's immunity that underlies the NAMBL case. It just doesn't because they've already been held. Their basic view that what they're doing is sovereign and not commercial has been rejected. And there's ample evidence that money came to the United States, and there's ample evidence that the gravamen of the case, which is they're benefiting from moving the money between Brazil and Cuba, was administered and managed out of Washington, D.C. So we have 2 very, very serious issues right off the bat of that being carried on in the United States. So for them to have to maybe defend on another theory, that's minor. That just doesn't rise to the level of what this court has said you shouldn't be able to do against a sovereign. And the second reason I would say it's not a viable approach is that it completely contradicts the rule against interlocutory appeals of discovery orders.
Well,
because
we have, I mean,
well, the court
NAMBL contradicts that general. It's just not the same rules of the game when you've got a foreign sovereign entity.
Well, the Supreme Court has said that the rule cannot, that the interlocutory appeal doctrine under Cohen should not be, so expansively interpreted as to swallow the rule against interlocutory.
Said that in Mohawk, a case not involving foreign sovereigns.
Again, so there's one thing about NAMBL that survives here, and that is the somewhat higher level of the standard for what's relevant for discovery. That much we concede, which was you have to make a specific allegation of a issue that's directly relevant to the jurisdictional issue. And that's exactly what Judge Boasberg did. I mean, he made it very, very clear, and I can read you his order to that effect. He said, plaintiffs have provided enough for a well-founded allegation that the commercial activity in question was carried on in the United States. And he cited the materials that we found for ourselves and put into the record, which are at pages 1163 to 1165 of the JA, that the activity in question was carried on in the United States. And all NIAMBL requires is a specific well-founded allegation as opposed to mere conjecture and surmise that has not been conclusively disproven. So what are the facts that he was referring to when he said that we provided information that showed that this was carried on in the United States? We found the executive committee report by PAHO that says in 2016 that PAHO had placed the project support costs from Mice Medicos, some $56 million, into the general budget, so they were being distributed across the organization. Now,
How does that
what?
help? Because the US brief in our prior appeal said, look, if these are program support costs, that's immune. That's not commercial activity and therefore.
Well, let me.
So how about where
continue.
they go and how they're used?
Sure.
How does that show they're not program support costs?
Well, what PAHO's sworn declarations say is that program support costs go to pay indirect costs of the program, right? That's what their sworn declaration says.
I know, but why is it coming into the budget in the US part of the indirect costs?
Well, it's just not. I mean, we asked for discovery on that, and they resisted as if they don't have to prove that. So they don't want to prove what their declaration says. But what we found does contradict the basic argument that they're making. It says that the final report from 2017, program support costs levied on all voluntary contributions were considered flexible funding, and they confirmed that Mice Medicos project had become a significant source of such funding in recent years. They said in the audit committee report that Mice Medicos project has continued to recover significant sums to PAHO for project support costs. Now, what we also provided, which is contrary to their declaration, is a rule that says that program support costs in the regular course of PAHO's business are intended to, in fact, flow through its Washington, D.C. headquarters. The point not mentioned by PAHO's declaration is that the policies governing PSC funds, and we've cited, and it's in the record, established that program support costs are credited to a special fund for program support costs under the control of its director, who may approve a distribution of earned program support costs for, among other uses, PAHO headquarters. And in normal times, PAHO taps the special fund for program support costs to supplement its general budget. Those are the facts that Judge Boasberg cited when he said that we've provided specific allegations of this money being used in that the program support costs money was carried on in the United States.
That's curious about how one does this money. I mean, money is fungible, right? I mean, I assume unless the money has little markings, special markings on it, there's no way of knowing, because Pan American Health Organization has lots of programs going. There's really no way of showing that the dollars that came from Brazil are the same dollars.
It doesn't matter. Well, I'm citing their records that say it's these same dollars, Judge. I'm not making this up. This is not speculation. This is PAHO's executive committee annual reports saying that the money from the Mice Medicos program, very specific, went into the general budget, and the rule saying that the general budget money is used for headquarters.
Well,
now,
that's what I'm asking is they even assuming it went into the general budget. I'm betting a lot of other things went into the general budget too.
It's a U.S. nexus. Judge Boasberg will decide whether or not we win on jurisdiction, but we're entitled to that information.
Is the general budget in the U.S.? Where is it? What bank account is that in?
They're arguing that we need the bank records to get the bank records. These are the exact records that Judge Boasberg said we're entitled to because it's relevant to our carried on theory. And so I think we came up with a lot that contradicts the statements they made in their sworn declarations. Judge Boasberg relied on to say, we've made the specific finding that NIAMBL requires. We did. And so now it's a question of, can we refute all of the factual arguments they're making, including this one, by the way, that it's sovereign and not commercial. Yes, we're entitled to that discovery as well. But what Judge Boasberg was very, very narrow. Banking records, discussions about which banks they were going to use, and he narrowed that to, it had to involve banks in the United States. And this question of headquarters activity, you know, when they got the case moved from Miami to Washington, Mr. Anderson, the director of administration, said that 6 of the 9 people who can speak to the plaintiff's allegations that PAHO profited from the Mice Medicus program and how the finances were used are located in Washington, D.C. That would be carrying this as, and this completely is completely different from the other cases because the gravamen of our claim is that
You've got people who can speak to how money is used in a location doesn't mean that that money was used in that location. That just means where the people with knowledge are.
But we're entitled to the discovery. That's all we're talking about here is that's certainly a specific enough basis for Judge Boasberg to conclude that that we're entitled to discovery about the movement of the money and the management of the program, which was all about PAHO getting 5%. You know, one of the arguments is, you know, how much of this was used to pay Cuba and how much was used to pay, you know, whatever else it was used for. I mean, 90% of the money went to Cuba. So like what program support costs did PAHO really have here? They collected the money and they put it to work in their general budget. That's a fee. Now, that's the argument we're going to make to Judge Boasberg. That's the fee they obtained for doing this dirty work for Cuba. And we're on very solid ground that speaks to commercial activity carried on in the United States. I have a couple of other points I'd like to make, Your Honor, about this because
Want to make them quickly then?
well, Judge Boasberg decided that the plaintiff's allegations stated, you know, a violation of the Trafficking Victims Protection Act with the gravamen being, you know, in the United States and commercial activity with a nexus to the United States. That was 5 years ago. This court decided its jurisdictional issue 3.5 years ago. Since then, we've been fighting with PAHO over records that we believe are entitled to overcome their factual motion to dismiss. As Your Honor pointed out, they chose to bifurcate the issue of legal immunity and the factual immunity. To the extent they have to, now deal with the jurisdiction, that's their choice. But for the plaintiffs who are, victims of serious misconduct that the United States government has recognized as being violations of international law and U.S. law, to have to wait 3.5 years to get records that Phoenix constructed, the Phoenix consulting case says, we're categorically entitled to. That's a great injustice. And the precedent they're pushing on this court to be able to have, one appeal after another. And when they say we're not going to appeal another one, no. If we win here, Judge Boasberg says, give the documents, and they're not happy with what he orders, and they want to contest that again under their theory, they would have an absolute right to another appeal ad infinitum. So as the Human Trafficking Legal Center wrote in their amicus brief, 40% of the TVPRA cases filed since the law was amended in 2003 to provide a private right of action are still pending. PAHO does not contest basic elements of what my clients have alleged, which is that they were trafficked by Cuba to Brazil, that PAHO was aware of it, and the PAHO benefited financially from the movement of collecting $2.5 billion from Brazil and sending it to Cuba and keeping at least $129 million for itself, for its corporate purposes. That is commercial activity carried on in the United States. And I respectfully request that the court dismiss the appeal or affirm on the merits.
Questions? All right, thank you, counsel. All right, Mr. Volchak, we'll give you 2 minutes.
Thank you, Your Honors. One thing Mr. Dubbin said at the very end jumped to the very top of my list. PAHO absolutely denies that it had any awareness that there was any human trafficking or forced labor involved in Mace Medicus. It is opposed to all of those things and certainly would not have knowingly participated in any of it. Mr. Dubbin, I think his presentation made clear their position is if you get one legal theory deemed to be facially viable, assuming facts to be true, you get jurisdictional discovery on remand on 5, 10, 25, 50, innumerable other untested, potentially unrelated theories. I submit that cannot be right. Think about how that would eviscerate IOIA and FSIA immunity. And think about,
Decide that in this case, though?
yes, I submit you do, Your Honor, because we submit that much of the discovery, and we're getting into characterizations, but much of the discovery, certainly at least 5 of the 13, 6 of the 13.
If we disagree on that, if we think that this is all within the scope of our previous decision, then we don't have, then
We have then we have a different argument about have they satisfied Neamble, but I would emphasize to the court, the district court gave only one reason for 5 of its 13 for ruling in favor of 5 of the jurisdictional discovery requests, that it was relevant to their theory of administration of Mace Medicos. But think about the mischief that would cause. Imagine if they had come in the first appeal and actually advanced administration of Mace Medicos, and this court had rejected it as legally insufficient under Youngquist. Surely they would not have been able to go back and then get discovery on it. So it creates all sorts of incentives to come in with just one theory, and you don't have to look farther than this case to see that in reality. Look at the bottom of page 32 of their brief in this court in the prior appeal. They basically disavowed administration of Mace Medicos as a theory. They said something very close to Ajo seeks to redirect this court's attention to its general administration of Mace Medicos, but plaintiff's section 1589B claim is based, the specific activity on which it's based is moving money for a fee. So in this court, they said, no, not administration of Mace Medicos. That's not our theory. They go back to the district court and they get substantial jurisdictional discovery on precisely that theory. That cannot be right. Your Honors, I have no time left, but if the court had any questions about the general budget, the 5%, that's legally inviolable and factually infirm. And I would be happy to discuss why if it would assist the court. Otherwise, I ask the court to vacate and remand.
Thank you. I think we've got strong arguments on both sides, and we thank counsel for their arguments, and the case is submitted.
Thank you.
It's possible for the government to